Mention for listing, my lord. Matrimonial appeal.
Criminal appeal.
Matrimonial appeal.
Okay. You can next week. Next week did you for hearing or what? Orders.
My lord, I beg to mention a criminal appeal, my lord, for listing, my lord. This matter was on the last occasion, my lord, lordship directed to list after.
For orders or what?
For hearing, my already this is appeal, my lord.
Order for hearing you pursue.
My lord, this is regarding bail, my lord, rejected by the special judge NIA, my lord.
Ultimately, it is hearing.
My lord.
Hello. This is an appeal, not
Yes, yes.
hello. A hearing. You make an application before the registry. All hearing matters. Yes, a fix. 10 and 11. Over ready otherwise. Kunti 10 or 10. I thought 10, 11, 10 or 11. These are fixed. These are fixed. These are fixed. 10 or 11 who are. Yes, Mr.
21 years of imprisonment.
Oh, yes.
So
Okay,
what is
Mr. She is there. Yes, Mr. Advocate General. Yes, anything?
One item was to be mentioned by the other side. In fact, state also is one of the appellant. Item number 429. Item 429.
Yes.
So, as this is not a permanent bench, lordship,
Not
this will this will require a very long hearing, lordship.
this will break up maybe in the
that case,
next week.
lordship, maybe please to fix the matter after 2 weeks
That is after vacation.
after vacation also.
Okay. The other side is ready.
Other side also was supposed to make the mention. They informed us that they will mention
Okay.
regarding grace mark, and all the parties have filed appeal against the learned single judge's order.
Mr. D. Hoikia, Learned Advocate General, Assam, assisted by
Because
Mr. B. Kosik, Learned Counsel, appearing for the state.
appellant, lordship.
Appellant.
In item number,
Appellant state.
appellant state in item 4, raised
item
by the
4.
other parties.
And for the respondents, for the state respondents in 5 to 9,
5 to 9.
5 to 9, has submitted that matter be listed. Any date you want, or immediately after
Immediately after
the
reopening.
immediately matter be listed immediately on a date immediately after the ensuing long vacation in October.
Yes.
Full stop. It is submitted that the request is made on behalf of all the sides.
Highly obliged.
Like to mention one case, my lord, for listing
Listing, hearing,
for 2020 matter.
hearing.
Hearing.
You make an application with a registry for hearing. Admission, orders, motion.
Item number 11 for hearing.
Ten is not there. Okay, deal. The counsel for 10 is available. Yes. She is not.
Arrived yet.
Oh. And then that one was 21 years imprisonment.
Yeah.
And order is consecutively. Just
Life sentence.
sentences are to run consecutively. That's all.
Reasons has to be there.
That is why
Yeah.
they are behind bars 21 years.
Full revision.
No remission. No remission, it will run into 50 years.
Yes.
Yes.
May I proceed, my lord? The gist of this matter is like this.
FIR has been lost on the next date of the occurrence. Occurrence happens to be, my lord, on 12/4/2020.
12.
12/4/2020. And the FIR, as per the FIR, my lord, at 12/4/2020 at 5:30 PM.
2/4/2000.
20 at
Ah.
5:30 PM, as per the FIR. Now, the FIR has been lodged on the next date of the occurrence on 13/4/2020,
You want to say occurrence at 5:30?
5:30, as per the FIR, my lord.
Ah.
Get changes in substantive evidence, my lord. Date of recording the FIR, my lord, registration of the case is on 13/4/2020 at 12:15 PM. And prior to that, my lord, there is a ZD entry, my lord, being ZD entry number 354. Case was registered under 447 and 302 of the IPC. Now, the informant happens to be, my lord, the son of the deceased. He is examined as PW1.
Where is the FIR?
Altogether, 8 witnesses has been examined.
Page 4 FIR.
Yes, let us come to the FIR. Page 4. Now, Suraj Naik. He is PW1. Humble submission is that I, Suraj Naik, resident of so-and-so, at about 5:30 PM on 12/4/2020, Sri Siva Karmakar, he is the appellant, a resident of so-and-so, killed my father, Bhim Nayak, by stabbing him in the neck with a scissor in the courtyard of our house itself. And this has been registered on 13/4 at 12:15. So specific time is there with regard to the occurrence on 12/4 at 5:30. Now, charge, my lord, at page 6, my lord, 447, my lord, and 302. Charge appears to be defective, but to what extent this court will go? To that extent, because the charge has to be very specific with regard to the manner in which the crime has been committed. But that's been missing in this particular charge under 302. The second charge with the second head. In what manner this been committed, although it's been reflected in the FIR, my lord, it's been missing in the charge. May I come to PW1, my at page 8, my lord. I know Siva Karmakar. The incident is of 1 year back and the date was 13th. It should be 12, my lord. That may be a typographical error, my lord, subject to what is on record, I don't know. At about 2 PM, now the time changes, my lord.
It will go recorded.
Or lower court records too.
Yes.
I was playing cricket in my village. My sister Anita came to that place and told me that Shiba was killed by our father. I came home immediately. I saw the dead body of my father on the bed with injury on the side of his neck. My sister Anita told me that my father was attacked with a scissor. My sister Anita told me that my father was attacked by a scissor. I, along with the elder brother, Bablu, not examined, brought my father to Dibrugarh Medical Hospital. Doctor declared my father as dead. Doctor told us that postmortem has to be done and asked us to come on the next day morning. Dead body of my father was kept in the hospital. We came to the hospital next day. After postmortem, we took the dead body of the father of our to our house and done the rituals. I lost the affair. Exhibit 1 is the said affair. Exhibit 1 is my signature. Police took my signature in other paper also. Exhibit 2 is the said document. Exhibit 2-1 is my signature. Now the cross. The incident is about 2 p.m. I have not stated before the police that my sister informed me when I was playing cricket. This is when an admission, my lord. I do not remember whether I said before the police that I saw injury on the neck of my father. Next, my lord, it is not a fact that I have not stated before police that on reaching home, I came to know that my father was already taken to AMCS hospital in the ambulance of the tea garden. Now, these two, my lord, one is admission. The next is been, I do not remember where this one. Now,
One
this
minute,
has,
Mr.
yes.
Please specific.
Yes,
Third line, deposition of PW1.
yes.
Do you think anything?
My sister Anita
No,
came.
no, no.
Which one?
Heading, page 8. Deposition of PW1. Read, go on reading yourself.
My name is Suraj.
Go on reading yourself. Above that.
My age is 20 years.
No, deposition
Oh,
of
oh, oh.
You go on
Right,
reading
okay.
yourself.
Difficult. I'm sorry, man. I didn't look in.
No, no.
It
No,
will be-
whether it will create difficult.
I don't think so, my lord. I don't think so, my lord. It is nowhere produced. We are on the law. We are on the evidence on record.
Because judgment is right.
Absolutely, my lord. Nothing will.
But
This one.
let us be specific. That is-
Absolutely, my lord. No question of
Okay.
prejudice. Now, if your lordship appreciates the cross-examination part, maybe to that extent, my lord is been always advocating with regard to Tahsildar Singh's case. It may not be. But these are all technicalities. For that purpose, if it appears from the evidence on record or otherwise, because 145, 154, 155, 150, these are all.
No, this is.
I really feel
No,
scared.
we are bound by it. It is not that
Absolutely.
I'll follow.
Absolutely.
We
There
are
is-
bound by it. Following one thing is one thing.
Yes, we
But
are bound.
When we are bound, we are bound.
We are bound. But one thing is there, my lord. What I'm on.
Yesterday I have seen
Yes.
for a offense under 302,
Yes.
either death or imprisonment for life.
Life.
But one trial court has imposed a punishment of rigorous imprisonment of 15 years.
Yes.
That cannot be done.
No. No, that
That is
cannot.
what?
That is,
Where we are bound, we are bound.
you are bound. So
You have
what-
to be
what I-
within the four corners of the law. That's all.
So what I'm on, that when in a case wherein a person's life is to be behind the bar, and a conducting counsel, my lord, wherein it doesn't conduct in as per the law, it doesn't mean that the person has to be behind the bar, because in a case of death sentence, the Supreme Court intervened, and thereafter, as because a competent counsel was not there, it been acquitted.
We have to see first whether there is a ring of truth or not.
Yes, that's true, my lord. But only on
Firstly, let us-
technicalities, a person, my lord, it will be
let us
very
have-
dangerous. Yes.
The entire evidence.
Yes, yes. I have not stated before the police that my sister informed me when I was playing cricket. I do not remember whether I said before the police that I saw injury on the neck of my father. It is not a fact that I have stated before the police that on reaching home, I came to know that my father was already taken to AMCS hospital in the ambulance of the tea garden. So now, my lord, Tahsildar Singh comes. This ought to have been, my lord, marked in the 161 that you have stated. Now, through IO, it is to be proved. So it has not been done. But by way of a contradiction, the IO has proved it that he has stated as such. Am I clear, my lord? Now, next witness comes in, my lord, is PW2. May I read it, my lord? Accused Shiva Karmakar and deceased Veem Nayak are my neighbor. The incident is of the month April 2020 at about on that day at about 3:30 p.m. I was having lunch in my house and I heard Veem daughter Anita shouting that her father has been killed. I got up and went out and saw Shiva Karma coming out from the courtyard of Veem and uttering that মই কৈছিলো নহয় মোৰ লগত নালাগিবি যি হল এতিয়া তহঁতে বুজিবি I told you not to confront with me. Now you understand what has happened. Shiva crossed me, and when I tried to enter to the courtyard of Veem, I saw Veem lying on the ground with blood coming from the cut injury of his neck, with some hissing sound from his mouth. I did not enter inside and came out and rang up Veem's cousin Rajesh. Rajesh did not come, but Holu Nayak, who is the uncle of Veem, came. He called the ambulance and took Veem to the Tea Garden Hospital. At about 9 p.m., police came searching for Shiv Karmakar, and then I came out from the house and narrated the fact to the police. I heard that Veem was referred to AMCS from the Tea Garden Hospital, and on the way he died. From the police, I was confirmed about the death of Veem. Along with police, we entered the house of Shiva, and the daughter of Shiva showed the blood-stained scissor kept on the table. Police seized the scissor list. Police seized the scissor list. Exhibit 3 is the scissor list. Exhibit 3(1) is my signature. Material exhibit is the said scissor. Shiva was not in the house at that time. Now let us go to the scissor list, my lord. That appears, my lord, page 69. Now, this seizure has been made on 12/4/2020 at 7:45 p.m., my lord. So and so, my lord. Now, with regard to the particular of the knife, kindly note down. One carved steel scissor with black handle about 6 inches long. This is very important. The weapon of committing the crime. Now, so far with regard to stain of blood and all such things, my lord, no investigation has been done. Now, coming to the cross-examination part, my lord, my grocery shop was open when I came home for lunch on that day. My shop is adjacent to my house. After Bola Nayak came to the house of Veem, I came to my house. It is not a fact that I have not stated before the police at about 3:30 p.m. I was having lunch in my house and I heard Veem daughter Anita shouting that her father has been killed and I went out. Now, this has been a suggestion that has been put considering the previous statement, and that has been proved by the IO that she has not stated as such.
It will still not.
Technically, it's like that. It is not a fact that I was not in the house at the time and I was in the shop. I do not remember the name of the daughter of Shiva. Her name is not Anita. There were 4 neighbors near my house. There is no shop near the house of Veem except me. In our line, there are about 15 to 16 shops and there are about 420 houses in our area. Near Veem, his daughter Anita and Sumitra were there. It is not a fact that no such incident has taken place and I have deposed falsely against Shiva for having old grudge against him. Now, this is the evidence of PW2.
According to him, hearing sound, he came to the place of occurrence. And he saw
Yes,
accused going out,
yes,
uttering some words.
yes.
But I have not
PW
stated before the police. But his presence was not
At the time of
contested.
occurrence.
Not contested.
His present itself, by way of a suggestion that you were not even present, it's a omnibus statement, general suggestions been
Not
provided.
contested.
Not to that extent, yes. PW3 happens to be the eyewitness. Now,
Have
if
you
your
proved
lordship-
any old grudge?
old grudge,
No, I have deposed falsely against Siva for having old grudge against him.
yeah,
Is there anything?
there is nothing brought on evidence on record. That's a suggestion, mayor suggestions. Where my burden it was there, but I have not discharged my burden. Now, PW3, my lord, happens to be the eyewitness. If you believe her testimony to be true, then it's a case of conviction. Now, before that, your lordship has to appreciate that it's a solitary witness, eyewitness, and whether she is believable. Because her substantive evidence and 164, which has been exhibited by the prosecution, two different facts with regard to material particulars. Now, if your lordship even then believe this particular witness, whether there is a scope, my lord, where to convert it into 304 part 1, because it is a case of single blow. That would be my line of argument, my lord. The incident is less than 1 year. On that day in the evening, I was sitting in my house and my sister-in-law Susmita was in her house.
Sumitra.
Sumitra, which is nearby my house. At that time, Shiva came to our house. Shiva asked Sumitra to give him the scissor to cut hair, but Sumitra did not give him the scissor. At that time, my father.
1 minute, 1 minute. Treat.
Yes.
He is Bagan worker.
Yes.
Okay.
At that time, my father returned home from work. Shiva told my father to give the scissor to cut the hair. My father did not give any reply. At that moment, Shiva attacked my father on the side of neck with a scissor, which Shiva had brought from his house. My father fell down. I went and called my brother Suresh from the field where he was playing football. Thereafter, my brother Suresh took my father in a vehicle to the Maizan Tea Estates garden. From there, my father was taken to medical hospital, but on the way, my father died. Police came to our house on that night and inquired me. Police took the scissor from the house of the Shiva. Police took my signature, exhibit 32, so and so, so and so. My lord, this is very important. This is my scissor. Material exhibit 1 is not that scissor that was not that scissor, as that scissor was a small one. So the scissor that has been stated to be clotted with blood, my lord, remains or smears or whatever it is, my lord, which was seized by by the scissor list, the exhibit, appears to be a scissor of a different kind of bigger in size, because according to her, it is a small one. I came to the court with my brother Suresh and sister Sumitra. Exhibit 4 is the statement and exhibit 41, 42 are my signature. My statement was recorded by Baido. Now let us come to the 164 statement, my lord, at page 71.
Is
71. My name is Anita Nayak. I am 15 years old. Bhim Nayak is my father. At about 5 p.m. on 12/4/2020, when my father was waiting in front of our house after returning from the market, my uncle Shiv Karmakar came near my father with a scissor in his hand. My sister-in-law Sumitra Mandal was standing nearby. My father asked Shiva for the scissor to cut my hair. Then Shiva said to my father, "I'll not cut your daughter's hair. I'll cut you only," and forcibly inserted the scissor into my father's neck. My father's neck started bleeding profusely and he fell on the ground. Taking the scissor in his hand, uncle ran away immediately. We immediately took my father to AMC's in an ambulance, but the doctor declared him dead. I saw Shiv Kamarkar killing my father by stabbing him with a scissor. Police seized that scissor. I recognized the scissor. That was the scissor with which Shiva Karmaka killed my father. Now, if your lordship appreciates her evidence, exemption chief, and this, with regard to material particulars in the manner in which it has been done, is altogether a different versus and inconsistent, my lord.
What are the difference?
My lord will kindly see.
Timing is definitely different.
On the date evening, I was sitting in my house and my sister-in-law Sumitra was in her house. So here comes sister was standing nearby. Now, my lord will kindly read, which is nearby my house. At that time, Shiva came to our house. Now here, came to our house. Now she states that when my father was waiting in front of our house after returning from the market, then Uncle Sipshamar came near my father with a scissor in his hand. Now here in substantive evidence he says, at that time Shiva came to our house. Shiva asked Sumitra, so house, my lord, how will you interpret, my lord, this honorable court will interpret. Inside the house and outside the house. Did not give him the scissor. So Shiva asked Sumitra to give him the scissor to cut hair. My sister-in-law was standing near my father, asked so and so. So version is different. Sumitra has been asked to give the scissor. Now here in 164 it's totally different. At that time, my father returned home from work. Shiva told my father to give the scissor to cut hair. My father did not give any reply. Now here it comes a reply. And the reply is, I will not cut your daughter's hair, I will cut you only. At that time, Shiva attacked my father on the side of the neck with a scissor which Shiva had brought him from his house. And forcibly scissored. That part is okay. Now, your lordship has to appreciate this evidence on record of this solitary witness, that whether she is trustworthy, whether she is consistent with regard to the manner, the facts which are admissible before the occurrence and after the occurrence, and how the occurrence took place, the manner in which it has taken place. If both are reconcilable, then conviction is okay. But if it is not, then she is not a trustworthy witness, then there has to be, my lord, her evidence has to be disregarded. Or otherwise, see for corroboration from the other witnesses, my lord. There are no other witnesses so far with regard to this.
Yes.
And my lord, PW1 and PW3, if we read it together, occurrence took place between, my lord, in the affair itself. My lord will kindly see.
He was not there.
My lord,
PW1,
Yes.
he was not there.
not there.
He was playing
Absolutely.
something.
My
He
lord,
came later on.
absolutely. He came later
But
on.
at least this PW2 and PW3, they were PW2, he came much earlier than PW1.
Yes. One thing I am
This
yes.
PW2,
what I appreciate,
Raju Kormokar.
yes, what I am appreciating is this. Both are all our family members. First thing, saying,
Raju is not.
I'll come to Raju, my lord.
He is not related.
I'll come to that, my lord. PW1 and PW3, whether it is reconcilable. Because at about 2 p.m., he was playing cricket. Anita came running, and thereafter he went on. So she has been saying in her substantive evidence at 5 p.m. So till then, my lord, everything is over. And nearby place. It's not kilometers. This is not reconcilable, my lord. And so far with regard to PW2, contradiction has been proved that when he reached home at 2 p.m. after getting the news, we went there. In the meantime, the deceased was taken to the hospital.
Who?
That was at first point of time.
PW2.
One, my lord.
One.
One after getting the news from her
We'll
sister.
Come back to one.
Yes, one at pace.
I will come back
Eight,
to one
yes,
later on, after going
So
through.
what I am on, my lord, this is my respectful submission. That two, according to him, and substantially occurrence took place. He came to home. By that time, the injured was taken to hospital and body was not there.
PW2.
PW1 has taken.
No, we'll come back to
Yes,
PW2
yes,
one.
definitely.
Later on, let us have the
Yes,
other one.
yes, other one. That Caesar, as the Caesar was a smaller one. She exhibits her 164 statement, my lord. I point out the regarding the difference between the two statements. Cross-examination. It is not a fact that I have not stated before the police that on the date of evening I was sitting in my house and my sister-in-law Sumitra was in her house, which is near my house. And that time Shiva came to our house. That Shiva asked Sumitra to give Caesar to cut hair, but Sumitra did not give him the Caesar. That at that time my father returned home from work. That Shiva told my father to give the Caesar to cut hair, and my father did not give any reply. Now this is a suggestion, my lord, which has been denied. When the
So
incident,
remain in the
yes, that is
area of
incorrect.
suggestion only.
Yes, suggestions. That's the problem in 302, my lord.
What to do?
My lord, that's why, my lord, our High Court
Yeah.
comes in. That-
We are trying.
Yes.
A legal aid
definitely.
council now what to do?
That's
If
the problem.
if somebody has the courage to be a defense counsel in a murder case without having the experience, who can stop?
Even our High Court has been in a death sentence
Things
case.
have been laid down.
Senior
I think
advocate
now
has to
laid
be
down
amicus
that at
curiae.
least 10 years experience
Yes,
as a defense counsel. Now things have been laid down.
yes, yes. It will take time. my lord.
Recently,
That's the
that-
irony.
10 years at least experience to
Yeah.
defend a murder case.
Absolutely. my- That is requirement. Otherwise, my lord, for not getting.
Everybody ventures otherwise.
Absolutely correct, my lord. And that's what I am on. That may result in the conviction of an innocent person also.
Right?
It's a sword with
Yeah.
double edge. It cuts both the ways. And this is a suggestion.
At least, I will not say to that extent. That somebody who has the chance to be acquitted on benefit of doubt,
Yes, I understood. my lord. Put behind the bar. It happens. That's the irony. And that's why, my lord, yesterday I was conducting a trial in special judge court, my lord. I was saying that there is a division bench now who doesn't take all nonsense. I'll follow Tahsildar Singh's case, court has to allow. Court allowed it. And I cross-examined, tried to mark it by confronting the witness in writing. He said it is not there. So it's an admission, it comes in. So the very example given in the Tahsildar Singh's case by the Honorable Supreme Court, 5 judges, that's been implemented now. But otherwise it's become very difficult for us. So this is the statement, my lord, of PW3, the only sole eyewitness.
when the incident took place, no one was there. When it started, Raju came. So Raju came.
Yes.
At
Next,
least this part, that next paragraph, cross-examination, second part.
yes. Suggestions, my
One
lord. It is
no,
not a fact, I have not
no,
taken it.
elicited, not suggestion, elicited.
When the incident took place, no one was there. And when I shouted, Raju Karmakar came.
Let us see. See page PW2,
PW2.
court line. I heard Bhim's daughter Anita shouting.
Yes.
So this, you have elicited.
That's
Defense
true.
has elicited now.
Huh.
Now both are jailing now.
My lord, one
This
line.
this is what I am telling that
Understood.
benefit of doubt
Yeah.
that you have that window you are closing
Closing.
by cross-examining the
Absolutely.
witnesses.
Absolutely. But here, my lord, with all respect to this honorable court, the main thing is regard to whether there is a commission or not.
It appears to be a truth now.
When the incident took place, no one was there. And when I shouted, Raju Kamarkar came.
No, at least this, and Raju says, I heard only the sound.
Yes. Yes.
Fourth line.
True, my lord.
So you have elicited.
Yes.
Prosecution has not elicited. You have elicited. She was not telling that in chief.
Yes, that's true, my lord. Things which.
So this is experience and inexperience.
Correct.
Your mentor and guide would not have cross-examined in this manner.
Absolutely. So
Yes.
this is the, my lord, evidence of PW3.
Others are again suggestion, which
Others
are denied.
which have denied.
Only this part is
Yes. Now
you
the
have
que-
elicited.
Yeah, and the question is before this honorable court that whether this 164, which is a prosecution document, these two statements can be reconciled. If it can be reconciled, then my lord,
But otherwise, this daughter of the disease is not a chance witness. She is a natural.
natural and
Her
present
presence
has
was
been
quite
shown.
natural. Inside the
Happy.
house, a girl of age about 15 years, quite nature.
But whether can be reconciled with regard.
We'll find that,
That's,
but that
But-
presence cannot be doubted.
yes. Sumitra Munda, PW4.
Sister-in-law.
Yeah.
Yes.
The incident is of about 1 year. It was evening. I was standing on the courtyard, and at that time, Shiva was coming towards our house. Vim followed Shiva. My house is in the same courtyard of Vim. I entered into my house. I heard a screaming of Vim, daughter Anita. I rushed out and saw Vim on the ground with blood coming out from the side of his neck. Vim's daughter went to call her brother. Shiva was standing there. Vim's father's family members came and I took aside from there. Shiva went to his house. Vim was taken to the hospital. Police came in the night. Anita was present near her father when the incident took place. Police inquired me about the incident. I was brought to the court to record my statement. I put thumb impression. Now, so far with regard to, my lord, the PW2's presence and after hearing the hue and cry of PW3 is concerned, this witness has never supported that the presence of PW2. Family members were there. But PW2's presence is not been supported by PW4. The cross-examination part, it is not a fact that I did not state before the police that Bhim Singh was coming with Shiva. It is not a fact that I did not state before the police that Shiva was standing near Bhim. It is not a fact that no such incident has taken place as deposed by me. Now, so far these suggestions are concerned, this has not been stated for the first time in the court. It's been proved by the Next witness comes in, my lord, is PW5. Uttam Karma. I know the accused so-and-so and this is so-and-so. The incident is of the year 2020. On that day at about 3:30 p.m. When I was coming home, I heard from the people that there was a quarrel between Shiva and Bhim. And for that purpose, I was submitting, my lord, that evidence on record says something has happened between the two. A quarrel broke out. So would your lordship...
This is hearsay.
Hearsay, my lord. But anyway, my lord, if your lordship appreciates the 164 of the eyewitness itself, solitary eyewitness, then there also is a altercations, my lord. Quarrel between Shiva and Bhim, and Shiva attacked Bhim on the neck with a scissor near the house of Bhim. I went to the house of Bhim, but in the meantime, Bhim was taken to the hospital. On the way to the medical hospital from Bagan Hospital, Bhim died. Police came around 7:30 and recorded my statement. I am Gaon Bura. I am the Gaon Bura of our Bagan line. Cross-examined. I have not stated before the police that on that day at about 3:30 p.m. when I was coming here, I heard people that there was a quarrel between so-and-so attack Bhim on the neck with a scissor near the house of Bhim, as police did not ask me about it, the same. It is not a fact that no such incident has taken place as deposed by me today. These were the suggestions, man. So what I am on from the evidence of this particular witness is concerned, the time of occurrence is very important because 3:30, whereas the eyewitness says it is a 5:30. So in the meantime, it was in hospital, the deceased was in hospital. 3:30, he came to know, heard it, came to the place of occurrence, came to know, the injured has already been shifted to the hospital. The time is, my lord, is very important with regard to this. And so far with regard to, my lord, observations in this case, the PW3 happens to be a witness, natural witness as such, present at this, becomes doubtful that way. And her own testimonies at two different authorities in a court of law and during the investigation before the learned magistrate while recording her 164 cannot be reconciled. Now, PW6 is the learned variable time of the court, my lord. There is nothing as such, my lord, with regard to deposition 15 years, why you have not put pertinent questions. There are infinite judgments, my lord. Above 12 years, the parameter is different. Above 12 years, below 12 years, parameter is different. And for that purpose, whole evidence will never go, my lord. Now, so far with regard to the cross-examination part, she has exhibited the 164. Cross-examination part, my lord, is very important because the contradictions has been put on record. This is a recording. It's correct. I have not mentioned the statement of so and so that I have asked her question to another. It is correct. The statement of so and so, it was not been mentioned to whom the translation was incorrect. So and so, I cannot say why the copy supplied so and so, so and so. It is incorrect to suggest that the statement recorded by me, respectively, has not been recorded in accordance with law. Now, very factum is not been gone to bring the contradictions with regard to 164.
No, what one is contradiction?
164 is a previous statement.
Yes.
Now, you have stated here as such, this witness has before you whether it is stated as such or not.
No, that should not be, court should not venture into that with the magistrate.
A person has been declared as an approver. An approver is been under 306, 307, CRPC, a procedure has been laid down. A approver is a person who make voluntary disclosure of each and everything, which consists of the inculpatory part as well as exculpatory part. Nothing to be kept confined, not disclosed. Everything has to be disclosed. Now, the learned magistrate, the court, before approving as an approver, the procedure is that judicial confession has to be there. A judicial confession has been recorded under 164, 281, a High Court rules and the Supreme Court judgments. Now,
Joyo.
he becomes a witness.
Joyo something, yes.
He becomes a witness of the prosecution now. Courts grants him approval on that particular facts.
No,
Now, certain facts which I have brought on record by way of cross-examination a particular witness, which he have not disclosed before the learned magistrate, how do I bring on record by way of this?
see,
I have to confront the magistrate.
see what the first thing before that, what I have noticed
Yes.
in this case. PW4 gave a statement
Yes.
under section 164 CRPC. And prosecution did not examine and did not exhibit that statement,
Yes.
right?
Yes.
C is, so far as 161 statement is for the purpose of contradiction.
Yes.
164 statement is both for the purpose of contradiction and corroboration,
Correct.
right?
Yes.
That first that witness is to be confronted
Yes.
or corroboration or contradiction.
Yes.
But that witness was not,
Done.
prosecution did not examine.
Exhibit.
That
Exhibit
did not
A.
exhibit.
Yeah.
How can you cross and plus the
Yeah.
magistrate now?
Yes.
Magistrate will depose about the procedure
Procedure.
he
While
has
recording.
followed, whether it is in total compliance of 164 plus reflection time if it is an accused. Whatever be permitted to depose about the veracity of the,
Sir, no, not with veracity.
that is what.
Never ever.
No, what you are saying, what contradiction?
No, no.
Coming to
even-
page 21, I am there.
Here there is nothing, my lord.
No, that is what I am asking.
There is nothing, my lord.
So,
That's been the lapse. That I cannot.
and defense also
improve.
cannot.
Yes, yes. I
Cannot.
cannot improve this case.
Ah.
Whatever is in the record is in record. So what I am on, that.
Is
whatever-
there any procedural irregularity?
There doesn't appear to be, my lord, and all,
Eh,
my lord.
so-
Has been denied. It's a suggestion,
So-
just a suggestion.
Though this 164 statement of PW4 was exhibited through the judicial magistrate,
Yes.
but since it was not exhibited
So
by the witness
yes,
himself,
my,
so nothing can be,
will not be looked into that particular
because
thing.
neither for corroboration nor for contradiction.
Absolutely.
That is the sum and substance of this.
That is true, my lord. That's been the law.
Yes, yes, just a minute. Let me refresh myself. Have you identified the paragraph? It has start from Nazir Ahmed
Nazir.
and
Nazir 1886.
then Taylor and versus Taylor,
Taylor versus Taylor.
and then Singhara Singh.
That is judicial
Uh,
confession.
This says that this section, therefore, by conferring on the magistrate the power to record statements of confession by necessary implication, next word, prohibited
Yes.
a magistrate from giving oral evidence of the statements or confessions made to him.
Yes, that's true.
On the contents, we
Yes.
cannot say.
So,
Outside the concept, procedure followed, signature taken. I have given him reflection time. I have asked him whether you are
Right,
so and
that's
so,
the
you will
law.
not be remanded to police custody.
Yeah.
All these are to be testified by him.
right.
But don't enter into the contents.
My lord, so far with regard to the parameters of a witness 164 or an accused, there are distinction between the two. I'm sorry to say.
161 and 164, yes.
Of witness and a accused. This is Nazir Ahmed is with regard to an accused, confessional. Taylor versus Taylor is confession. So confession is with regard to a accused person confessing his guilt. Parameters has to be there with 281 and High Court and Supreme Court judgment.
Hmm.
So far with regard to 164, it's a previous statement in writing.
164, but 164, 281 is read with 164.
Yes, yes. That is with regard to accused.
No.
My lord, what is
Let us
164
see
of a
164.
witnesses?
Let us see.
My lord, there are judgments wherein if the police officer forwards a witness, their own witness, for recording 164, the court has to be cautious. Because the
No.
prosecution doesn't have faith in their own witnesses.
Yes.
So that is the parameter.
Section 164 is
Yes. Witness.
recording of confessions and statements.
Is it? Do two parts.
Yes, two parts. Subsection 5 comes in.
Right.
Any statement other than a confession
Yes,
made under subsection 1 shall be recorded in such manner hereinafter provided for the recording of evidence as in the opinion of the magistrate best fitted to the circumstance of the
Yes.
case.
yes.
And the magistrate shall have the power to administer oath to the person whose statement is so recorded.
Yes.
Right?
So parameters are
Then
different.
thereafter,
In my lord, 164 of witnesses.
so far subsection 2 is concerned
Yes,
that he is not bound to make any confession.
yes.
All these safeguards
This is
are to be
regard
followed in
accused.
case of confession.
Accused, yes.
Then third also,
Yes,
subsection
Accused.
3,
accused.
subsection 3, confession.
Yes,
Subsection 4 about the memorandum and
Yes.
281. So it is ordinary to be recorded,
yes,
right?
yes,
And veracity of the statement is not to be extracted from the magistrate. It is to be, the witness is to be challenged.
witness is to be challenged.
No, magistrate
my-
means that
to
why
my view, my lord,
magistrate who is sitting in the,
My lord,
and there are ample, so
I have to do the recharge part, my lord.
so far, I think common sense
Yes,
that magistrate cannot say about the veracity of the statement made by the
yes,
witness. He is sitting in a chamber, something has been done. He is not witness of the facts.
yes,
He is not witness to the facts.
absolutely.
He cannot be cross-examined on that point, on the facts.
If that is so, my lord, and that's been the logic with respectful, my respectful submission would be this.
No, about witness, I'm saying.
Yes.
I'm not
So,
saying about
if-
approver and all
No,
these
no,
things.
no.
No, bring in
In
approver.
any witness, my lord. IO has the power to investigate. He's not an eyewitness. So whether during evidence, the purpose of evidence and the cross-examination is to elicit the truth,
Yes.
including attending circumstances, what is stated and what is not been stated. Now, if we read it with 145, any statement, previous statement. Now, there has been a domestic violence case in a given case. There is a FIR connected with it. It is also a previous statement, and the statement given before the IO is also a previous statement, and before the magistrate is also a previous
But
statement.
the law says 161 says, and 161, 145. What is the previous statement?
No, it's not confined to it, my lord. I'm sorry.
161, 164, I am clear it is previous statement. I
and-
don't know about,
And my lord, 145, my lord, there are judgments. 145 is not confined to only 161 and 164.
okay, we are
Any
into,
statements
Okay.
at earlier point of
we are
time.
into 164 only here.
Yes, 164 of a witness. my lord.
Now, PW4,
Yes,
he was, that statement was not exhibited to her.
yes. So it goes, my lord. Nothing as such. I have nothing to say with regard to PW6, my lord, because nothing has been brought on record. Only suggestion been there.
Yes, so far PW3 is concerned,
Yes,
her statement, she has said, that judicial magistrate has said, I have recorded the statement.
yes. That's
That
all.
part is okay.
That's
Anything in the cross? so far?
nothing, my lord. Nothing. Suggestions denied. So it's no.
For the benefit of any, for the defense?
No, man. I have gone through it. Devarshi Sakravati, he's the doctor, my lord. This is very important, my lord. His statement has been given in his paper book twice, my lord. I come to page 25, same evidence.
Okay.
According to him, my lord,
এইটো দি দিয়ক তেখেতৰ নেকি?
I will come to the inquest also.
ধনজয় মোৰ হলে ধন কিবা ৰাখে জাষ্ট এ মিনিট yes
Now, my lord, I will appreciate, my lord, with regard to the inquest report and the medical. Because as for this postmortem report, he was wearing a shirt. When he was being forwarded to the doctor conducting postmortem, my lord, if I can read it, my lord, at page 25.
okay let us see an inquest
Inquest, yes, my
64
inquest at 64.
13
Yes.
14:30 AM.
If it is in neck side, right hand side, my lord, this kind of injury, blood profusing art, definitely there will be blood smear in his cloth. Whether it's been sent to scientific examinations, I don't think so. Evidence on record doesn't
No,
say
no,
so.
regarding wearing of shirt, you are saying.
Yes, that is
In the
my lord
inquest
at
report-
postmortem report.
No, inquest report, no.
Inquest report, my lord, will clearly see.
Is
Head,
there anything?
nothing, my lord.
Okay, that is.
As if, my lord, that ought to have been there, my lord. That what injury is there and how the body has been found and in what conditions. This ought to have been reflected. What shirt, what this one, that one, nothing has been there. As if the body has been found without clot, as per inquest report. But the same body has been sent to postmortem examination, my lord. And doctor says so, my lord, as per records. PW7's evidence, if your lordship appreciate it. $25. May I read that page 25, my lord?
Hmm.
On that day, 13/4, I was on duty as demonstrator of AMC's Dibrugarh Department of Forensic Medicine. On that day, I performed postmortem examination on the dead body of so-and-so, 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 so-and-so. The deceased were brought and identified as code so-and-so, so-and-so. On examination, found the following. On examination, found the external appearance, average bill, sweaty complexion, wearing a long pant, a red pant, and underwear, and a shirt. Now, these materials were never been exhibited, my lord, during the trial. A seizure was exhibited through PW3. She disagrees that this is the crime weapon. Eyes and mouth closed, temperature so and so, so and so, so and so. Number of injury. A stab injury 1 centimeter, 0.5 centimeter. So, my lord, the injury is this. Deep. Over the right side of the posterior lateral aspect of the right side of the neck from the middle line and 7 centimeter below the lobule, somewhere here, my lord. The shape of the wound is spindle shape and the injury is directed towards directed upwards and medically transverse through the floor of posterior triangle muscle, that is elevator scapulae, splenius capitis, and so and so, so and so, so and so, the apex of the triangle to injure so and so, so and so, so and so. Tissue plane of the whole side. Now,
Occipital, no? It's medically not. Ruptured.
rupture. Whether this can be caused by a seizure. And the injury, kindly see, my lord. 0.5 to 2 centimeter deep. .5 centimeter muscle deep. 1 centimeter into 0.5 centimeter muscle deep. And that is a fatal. Earlobe is here, my lord. Very limited
Hey,
knowledge
doctor,
with
sir.
regard to medical.
I'm trying to find out.
Yes.
That is why.
Skin tag are found.
I
at
don't
the-
even remember at least the names of 4 medicines, so I don't know. Occipital. And oh.
That is elevator, so and so, so and so, so and so, so and so, so and so. And that somewhere, my lord, earlobe is been mentioned. 7 centimeter below the lobule of the left ear. Middle line and 7 centimeter below the lobule of the left ear. Left ear.
Occipital nerves.
7 centimeter would be here. Difficult.
Occipital nerve. I think artery, it is somewhat related.
Here there
A
are
large medial branch of the posterior primary ramus of the second cervical nerve, mainly cutaneous to the skin of the back of the scalp. Branch of
1 centimeter into 0.5
It
centimeter.
emerges the posterior border of muscle and supply the skin on the side of the head, behind the auricle and part of the cranial surface, auricle, third occipital nerve, a branch of so and so.
And it comes to my
Oh,
mind,
1 minute,
I
1
need to
minute.
understand.
Oh, 1 minute. Occipital artery.
Hmm.
Occipital artery. That is ruptured, right?
Yes. A injury, step injuries, penetrating injury.
The apex of the triangle to the injured, the occipital artery and the artery is completely ruptured, completely.
My lord, where?
Now, page 26,
Page 26.
first 3 lines.
Yes. The tissue planes of whole cells of the neck and fill up with liquid clotted blood. The sensor muscle up to apex of the triangle to injured occipital artery is completely ruptured. Yes, that is there. So what I am on?
No, that supplies blood to the brain.
Yes.
And it is ruptured.
Brain hemorrhage. So
That
what
is
I-
a large branch of the external carotid artery, occipital artery means,
Yes.
running upwards and backwards with the posterior belly of the digastric muscle to reach the back of the scalp. It supplies
Blood manner to the brain.
its descends branch with the vertebral, deep cervical and transverse cervical arteries. So main durameter in the brain supply blood by this.
Is it so? No knowledge.
I am trying to
Yes,
understand.
yes.
And this is ruptured. That is why even if the
Small one injury.
one, but that
It
got
can be
ruptured.
fatal. Absolutely.
And as a result, because otherwise it is 1 centimeter to 0.5 centimeter.
Yes, that's what it is.
But
It can be fatal.
it can be fatal.
Fatal.
I think that is, what is the opinion?
Opinion has been there, my lord. Injury described was antemortem and caused by sharp pointed weapon and homicidal in nature. Now, my lord, cross-examination, body arrived at 12:30 PM on 13/4/2020 and examined at 1 PM. Now, my lord, my query is this. Whether this weapon that was present, that was seized, that was exhibited to witness is been part of the record, part of the evidence on record. Now, why this is not been put to the witness?
Huh? No.
The person, if I am correct, my.
No. First
If it's
injury,
been a-
let us
That
have
is
the
something
injury.
there. I am not going to that extent. What I am on,
No, medially and transverse to the floor of the posterior, that is levator. Occipital artery to বুঝে লড়াই খেলা কথা ব্রেইনত যায় তো এইটো ব্রেইনত যায়
it cannot be argued.
This is a hope.
Mm.
The neck too. It funny like.
My lord, maybe suggesting this, that it's been this and thereafter been turned. That would be difficult. That from the medical evidence, my lord, doesn't support it. If that is so, my lord, this hole will come up. This link will never be there, my lord. We'll kindly see. Stability muscle deep is present, right side, posterior, so and so, so and so, so and so. It will protect. This protect will not come, my lord.
Index.
If it's been
Margin of wound are found regular. That means it is sharp.
it's sharp. And my lord, if it is been, my lord,
Index
removed this way,
and
then
placed.
it comes out. This will be
Spindle
protect.
shape, spindle
That
shape,
is
right?
never happens, sir.
Skin tags are also there.
My lord?
In tags are also there.
No, skin tags is intact. My lord, where? my lord?
Are founded place.
In tags are.
Margins of owns are found regular and skin tags.
Skin tag.
Skin is been tagged. So if it is been this way that putting and thereafter drawing in, then this will protect. It will come out, my lord. Maybe, my lord, limited knowledge, my lord. It appears to.
No, we are also trying to understand. It was spindle cell.
What I am on, my lord,
Yes, it এটা কথাই নহয় media channel. But whatever what has attracted my notice is
Hmm.
that occipital artery was injured
Injured.
and that artery was completely ruptured.
rupture.
And so far with the limited knowledge, it supplies blood to
Blood
the
to the-
upper
Yeah.
this part.
Yeah.
Basically, that what some dura that mainly brain
Yes.
that part.
Yeah.
That
My lord.
I think
What I am on, my lord,
circulation stopped and person died.
yes. What I am on, my lord, this crime weapon was never been.
And no cross examination.
Let it be on record, my lord, as it is. Isn't a duty, I put it to myself, my lord, isn't a duty of the prosecution to bring on record that whether this knife can cause this 1.5, because if that is a seizure and a big seizure, my lord, it cannot be 1.5, 1 to 0.5 injury, my lord, if it is being inserted. That will be much more than that. First thing. Second thing, why this particular crime weapon is not being, my lord, confronted with regard to whether this injury can be caused by this. It's not been done.
That is one part
Yes,
for the prosecution
yes,
could be, but that is also not that fatal. But
Yeah.
at the same time, defense could have also
Done it.
confronted him.
possible.
Both could have done it.
Yes, court could have. done.
Both, if
There
they
are two
have the
things.
confidence to do it,
So,
they could have done it.
yes,
Defense could have also done it.
yes. So in
That
this
it
situation,
is not possible
yes,
to do this
Yes.
by this kind of a,
that was
at
very
least by
important.
a seizure.
Yeah, that was very pertinent, my lord, from all the sphere.
From all-
Now, in absence of that, my lord, in absence of that, my humble and respectful submission is this, that
Hmm.
this goes against the prosecution. Why I'm saying so, my lord? This shows that it has not been done because of the
Mhm.
fact that it will come on record that this seizure cannot cause this injury. And if it's been possible and it has not been brought, then, my lord, adverse presumption has to be there on record. The doctrine of adverse presumptions comes into. If there is a situation wherein, my lord, a marpit took place out here in the court's room and CCTV cameras were there, now police investigate it, doesn't seize the CCTV cameras, adverse presumption comes. So in that factual matrix, my lord, adverse presumption comes in this case also. Because 0.5 and 1 point, that is, I am very important, my. That, my lord, the size of the seizure, my lord, it can may cause, but size of the seizure is very important. Whereas the witness is saying it is a small seizure, it's been caused. Whereas the seizure that has been produced before the court is a large seizure and it's been denied by the witness herself. That goes into the root, my lord. And moreover, my lord, in the receiving end, my lord, I would pray, my lord, with folded hands. Nobody is born criminal. And there is no evidence on record to show that he tried to give a second blow or as such. Heat of the moment and as such as whatever the general exceptions are there to make out a case on 304 part 1, some kind of relief, my lord, if possible, my lord, that way.
Now let us see his 313.
Yes. So, my lord, PW 8 is there, my lord.
Okay.
That is the IO. So and so, my lord, Anita Nayak, all this seizure has been done, exhibited. My lord, the cross-examination part might take it directly, my lord. Suraj Nayak PW had not stated before me that he had seen injury on the neck of dinghy of his father. It is correct that Suraj Nayak PW1 had not stated before me when he reached home, his father had already taken by the ambulance. It is correct that Raju Karmakar PW did not state before me that about 3:30 p.m. I was having lunch in my house and I heard Bhim's daughter Anita shouting that her father has been killed and I went out. It is correct that Anita Nayak did not state before me that she went and called her brother Suresh Nayak when he was playing football. It is correct that Sumita Mundratri did not state before me that Bhim had come with Shiva. It is correct that I have not recorded the statement of Bablu Nayak, whose name is mentioned as D in the sketch map. It is incorrect to suggest that there was 15-16 shop. It was a very large area. It is correct that I have not recorded the statement of witnesses who resided nearby, as they were not available. It is incorrect to suggest that the seizure seized by me is not connected with the instant case and that I have produced the same and connected the same with the instant case. It is incorrect to suggest that I have conducted the investigation perfectly and submitted the charge sheet on baseless material. My lord, 313 statement, my lord, at page 31, he denies everything. And he answers certain things.
He has his own story,
Yes. So far,
but
PW.
never taken during the trial. See,
Huh.
question number 3 perhaps.
Yes. Allegation are false. I had gone to the bazaar. It was Sunday. I had also consumed little alcohol. I cleaned my hands and foot and drank water. I heard halla. Then, when I came out, I saw that many people had gathered in the sutal of Suraj. I went to see his father was lying there. Suraj told me that his father used to stay with me, and he asked me what has happened to his father. I told him that I had gone to the market and had come back, and I do not know. Now, a person, my lord, who is accused of murdering, saying and in 313 that I did have
I
alcohol.
cannot say who took.
His Anita told him that his father was attacked with a seizure. What do you, I cannot say and do not know anything about the seizures. PW1 stated he along with his elder brother, so and so, so and so, so. What do you have to say? The Veem Nayak brother beat me up on the head. I cannot say who took their father away. I cannot say. I cannot say. Allegations are false. It takes 5 minutes to go to the house of him from my house. I cannot say since I had gone and come back from the market. Total denial.
At one point, he admitted that I went when I went to the place of occurrence.
Yes, after
when
the
I
occurrence. And he talked to PW1
these are
also.
completely absurd things he is saying
Yes, yes.
without taking anything in that line during the entire course of the trial.
Yes. My lord, that has been on record. my lord.
These are all on the advice of কি নিজে কি বুঝিত ব্যাপার
Last question is very important. My lord, page 37, my lord will kindly see. I'm innocent. I did not kill anyone. I was falsely implicated. At night, I came home to see whether my wife has been beaten or what. She told me that if I do not go to the police, she will be harmed and my daughter will be harmed. I again went to the Bagan at night to save my family. In the early hours of the next day, I myself went to and presented myself to the police station to save my family. I did not kill him. This is the allegation.
wrong statement, false statement. Come to page 29.
20?
9,
Yes. Yes.
fourth line.
I took on
In the meantime,
In the meantime, I learned that the accused Sivakuma was in Assam Medical College. I went there, apprehended the accused, recorded his statement, and forwarded the accused to the court. I also forward so and so, so and so, so and so. There is no cross-examination, but I don't think so. It will
Hmm?
be wrong or false. It cannot be
You
accepted
cannot
that way.
presume all the time that
Because
police
it-
personnel
my lord,
will say
that record will reveal. my lord.
falsely that you cannot allege anytime,
Yeah.
all the time, 24 hours into 7,
Yes.
that police will say wrongly.
No, what I am on, the place
Right?
of arrest,
That is-
no, no.
That is
The
the,
place
all
of
the
arrest,
things, police cannot
Well,
be doubted
absolutely.
about
What I am
these-
saying
these
so,
facts.
yeah, what I am saying, so the record will reveal that. From the record, the place, Caesar, the arrest memo itself, the place of arrest would be reflected, my lord.
Because he said, I presented myself in the
himself.
police station to save my.
And if the arrest memo
Okay,
says so,
Mr. Das, please check.
arrest memo, and if
This
it is,
false explanation, all
Yeah.
this has dented the case of the defense.
I will
this-
be a
this-
lawsuit discussion.
This,
my lord.
no, 313.
Yeah.
At least.
It's a very
you
important
should
one.
keep
Yeah.
silent or, but he is going here and there, everywhere.
Have a record to.
Record
everyone.
sab-
Most highly so.
Please
Yes.
see this case diary. At least case diary.
And considering this, my lord, what I will argue.
There could be various defenses.
Yes. Deputy postmortem report. Arrest memo to lower court or record jot hobo. OP. এইটো চোৱাচোন এইটো চোৱা DBI নেকি DBI নেকি
এইটো যদি হয়,
outpost he has been arrested. From the
Suppose,
arrest memo.
huh?
Outpost he has been arrested, not from MMC. Forwarding also, my lord. First time when he was forwarded to the court, that part with regard to arrest
No,
from the
let us
MMC
have
is
the case diary.
not
Let-
reflected,
let
not
us get-
reflected.
Suppose
Yes,
the incident is true,
yes.
then if from that point onward, what will be your submission?
Then my
Suppose
lord,
the incident is true.
is true, heat of the moment, here's caused it, my lord. And so, my lord, being a, my lord, nobody has the right to take life of one. But in the heat of the moment, he has taken it. Only a single blow is there, that too with a scissor, no repeated attempts has been made. In that case, my lord, culpable homicide not amounting to murder, my lord. These are the provisions that has been made in the IPC itself to categorize a special category of cases which falls under that. And that not amounting to murder, part 1 and part 2. This is a person who is uneducated as such. He may have the knowledge with regard to, my lord, causing the injury, but not to that extent of causing death. If you would have been having the knowledge, my lord, then you would have given different repeated blows, my lord. And why punching in somewhere in 1 centimeter and 0.5 centimeter? He doesn't understand that there is the blood circulation through it. And if it's been injured in any way, then blood will be oozing out like anything, my lord. In that circumstances, my lord, considering everything, my lord, on record, it can be a case of 304 part 1, part 2, my lord. If the intention was there to causing only injury, but no knowledge with regard to, then it will come under part 2. There has been a judgment I am relying in, wherein in the heat of the moment,
But the situation of the heat of the moment is not the. Well, situation of heat of the moment, as if suddenly the heat of the moment.
yes,
Stabbed.
yes,
This, that situation of circumstances is not clear, not clear.
not clear, but
Just should have been there, some line that there was quarrel, but
That's
you know, complete denial case.
yes,
Sometimes it may not rescue.
absolutely.
I'm not saying Mr.
Yes, yes,
Sometimes you have to visualize the situation that this person cannot be rescued out of
yes.
culpable homicide. That it may amount to murder or may not amount to murder. So
Yes.
at least should have been there
Yes.
that it preceded by some kind of quarrel.
Yes.
Then
But that quarrel word has come on
because this
record.
PW2, they-
164 statement also comes on record. 164, my lord. If some indications, my lord, I am addressing this honorable court
Should
and
be
nothing
my-
like a
my-
mercy
my-
petition, nothing else.
my
A
ঘৰৰ
person
কামৰে,
who has
কি
committed a
আছিল?
crime and that too
বিহৰ
it's not a
ওচৰতে
premeditated
ৰাতিয়ে ৰখি
murder
আছিল।
or pre-planned murder as
Yeah,
such.
those are civil
It appears from the
cases,
evidence on
yeah.
record. In that case,
Journalist
my lord, on the
people-
given circumstance, on the basis of evidence on record,
জীৱ-
whether it can be
Security.
deduced that it's not a pre-planned murder. If it is not so, my lord,
মানে
then it's and buts, small
Yes,
things comes
Shiva.
into my rescue.
কিবা থিয় হৈ আছে কিবা আজিকালি কিবা কথা
Oh.
বতৰা হয় মই মানে ইমান কাজিয়া লাগি এইটোৰ পৰা গম পাই সুমিত চৰণ সুমিত এইবোৰ নাহে নহয় এতিয়া প্ৰব্লেমটো হৈ কিন্তু সমস্যা হৈ যায় ন এইটো কনফাৰ্ম কৰিব লাগিছিল ন এইটো কনফাৰ্ম কৰিব লাগিছিল ডিফেন্সো নকৰে 207 copies are there. The defense could have done a better effort.
I tried to, my lord, make it as literal.
We have read the vernacular. Yes, it
Can be
so-
converted.
the
into-
yes, we are examining
That
that
your
part. We
lordship,
are
all mercy, my lord.
but the incident is true.
Incident is true.
But it,
It
maybe
happened.
you go through and
Definitely a
we'll-
person has lost.
we'll hear you.
Some judgment I will cite, my lord. Oblige.
Better to cite one.
12-4.
Not okay.
13-4 is the affair at 12:30, my lord. He was taken to hospital, brought dead.
Since then, he is in custody.
Yes.
থাকিব নহয় copy of the order sheet. Sections, yes. Is in charge seated. Is in jail. Judicial custody. এই ফলো কৰোঁ ৰেকৰ্ডটো আছে নেকি এইটো বি এইটো সেশনস কেছ এইটো নেকি এইটো Looking for 13.
Oh, over 34.
আৰু এটা কথা কোনটো হ'ব বয়সটো কিমান হ'ব 13 ওলাব 31 years 31 married man family yes
Yes. My lord, I rely on a judgment of this Honorable Court Division Bench Honorable Justice B.D. Gyani and S.L. Saraf, my lord. Here the case was this, my lord. Prosecution case was this, that one Jugendranath Bora was an employee of Oil India Gas Commission, lived with his wife and daughter in village so and so so and so. Now this person came with three persons who were waiting outside, my lord, and thereafter assaulted the deceased persons. Injury are three in numbers. So far evidence on record comes in that a single blow has been given by this particular person, appellant, on his on the head of the deceased, and he was convicted under 302, my lord. But this honorable court set aside the judgment, my lord, and thereafter giving the benefit of probation of Offenders Act 4 and 6, my lord, he was released, considering factual matrix of the case, my lord. That is 96.3 GLR, page 5. Paise baito. The important paragraph is this, my lord, that why this benefit was given, my lord. That no attempt was made by this particular appellant to give repeated blows. Paragraph 9 is important. Now coming to the overt act as attributed to the appellant and proved by the prosecution, the appellant Ramesh dealt with a blow which fell on the head of the deceased. It is nobody's case that while dealing with a blow he aimed at the head of the deceased, nor there is an iota of evidence to suggest that he was in any manner prevented from repeating the blows by intervention of someone, although. So here is also a case wherein there is nothing on evidence on record that he gave a second blow, or there, when he fell down, the appellant was, could have given the repeated blows, but he did not. And that way, my lord, here, Probation of Offenders Act, my lord, is made applicable, and thereafter he was released, my lord. Another judgment of 2008, my lord. Here in paragraph 7, that is very important, my lord, 300 IPC, the exceptions has been discussed, my lord. In between the lines, my lord, I'm not reading everything. The help of exceptions 4 can be invoked if death is caused A, without premeditation, in a sudden fight, without the offender having taken undue advantage or acted in a cruel or unusual manner. Fight must have been with the person killed. To bring the case within exception 4, all the ingredients mentioned in it must be found. It is noted that the fight occurring in exception 4 300 is not defined in IPC. It takes two to make a fight. Heat of passion requires that there must be no time for the passion to cool down, and in this case, the parties have worked themselves into the fury on account of the verbal altercation in the beginning. So there was an altercation because the evidence of PW3 has to be taken in altogether, the 164 also. And there is an altercation with regard to this. And that resulted in giving a blow, which he did not under expectation that it would be fatal to the deceased, my lord. So it was reduced to, my lord, 10 years from life, my lord. এটা দিলে I was advancing my argument that the 164 and the substantive evidence is irreconcilable. And that's why the benefit of doubt should go to the accused. And always it is the burden of the prosecution, my lord, to prove beyond reasonable doubt that the murder weapon used, for which it has been projected the accused appellant has used that particular scissor. Not whether Caesar can use that particular weapon.
So where I want to know,
Yes.
will it be a two-prong submission or single prong? Single prong.
Yes.
That one is that you are going for clear acquittal.
My lord. That's two way of my argument, two side of my,
And second part is
Is-
that on the alternative, even if
yes, accepted in entirety, my lord.
then
It may be a case of,
either that there are two ways to travel.
yes,
One is culpable homicide amounting to murder
yes,
and culpable homicide not
Not
amounting to murder,
yes,
right?
yes,
Then culpable homicide not amounting to murder,
my lord,
and there are two subcategories.
yes,
One is with the intention, but falling within the exception.
yes.
And the second one,
It's knowledge.
not with the intention, but with the knowledge.
Knowledge, correct.
Right.
Yeah.
Now, which one? Because I have to deal in that manner.
not
If you
burdened
do
with-
that,
No, my lord, I will not burden my lord.
That is
And
why
I know my
I
lord.
am clearly.
And I am lucky enough that my lord has given me a patient hearing, but what I am expecting
that
that it will
See,
be justice and it will-
culpable homicide amounting to murder, it will attract 300.
Yes,
Culpable homicide coming within the exception 300 part 4 part 1,
yes.
or
Part
culpable homicide not amounting murder but with the intention,
Yeah.
again 304 part 1,
Yes,
but culpable homicide not amounting to murder without the intention but had the knowledge,
knowledge.
then 304 part 2.
So my argument is limited to this, my
Yes,
lord.
so I am
Yes, so I
cutting
take
it
up,
short
yes, come
so
short
that
and,
he can
yes, he can reply.
respond.
My lord, what has come on evidence on record only on the basis of-
Seizure appeared to be in hand,
My-
but it was not used.
Yes,
It was not used initially.
yes,
PW3.
yes,
The actual story was in the 161 statement, but that
Yeah.
has not come. So
Come.
we cannot now make use. We cannot now make use. I'm making it clear. Whatever is there on the record,
yes,
PW3,
yes,
from PW3, it appears
Yes.
that he had a seizure already in hand,
yes,
but he asked for a seizure
yeah,
from others.
yes,
And when this man did not reply,
yes,
that deceased,
yes,
Shiva asked him to give the seizure to cut the hair.
yes,
Page 13.
yes,
Then this man, deceased, did not give any reply.
yes,
Then Shiva attacked with the seizure which the Shiva had brought from his house.
yes,
This is substantive
yes,
evidence.
yes,
Now, anywhere PW4 said that there was something, my house rust called, anything like quarrel.
no, it has not come from this matter, from so and so.
Screaming,
Screaming is there, my lord.
screaming, that is
It is not
after
there.
that.
PW5 stated about a quarrel.
That is hearsay.
Yes, And-
when they are sitting, Sumitra, they're by house, saying to ask Sumitra to get a seizure to cut it. They were asked. Till now. If
But it is on record, evidence on record, and we cannot go beyond it, my lord.
so the
That-
bloodstain,
There is exchange of words between the two. Premeditation is not there. Repeated attempts is not there. His qualification, his age, and uneducated is to be taken into account. That he has not aimed it and thereafter thought about killing of a. He maybe have the intention to causing injury, but not to that extent of killing a person.
defense had ample opportunity.
Absolutely, ma'am.
No, I am
Absolutely.
trying to find out that.
That
I was having glance. Put on it. It put to 160
PW two, my lord, if your lordship appreciates.
One,
PW2.
let us see 164.
I saw Siva Karmaka coming out of the courtyard and uttering that so koisilu so and so so and so.
That goes against you. Then it is with an intention.
Yes.
My uncle Anita. Okay.
71, my lord, PW three,
Let us see
164.
Forcibly inserted. But I was waiting in front of you after my uncle came. Here my father would just sit here. Hmm. 164 to the other damaging. PW one capacity. একটু এক্সিবিট নকৰিলে না You will hear Mr. Das.
Yes.
Mr. Sok.
May I take the leave, my lord? I have another matter. my lord. I'm deeply obliged.
Lordship, firstly, I want to state here that if you go through the facts of the case, Lordship, 3 persons are there at the relevant point of time. Firstly, the accused, second is the eyewitness, and third is the deceased, Lordship. And deceased has not stated anything about the quarrel, Lordship. Eyewitness, PW3, Lordship. Moreover, he has given the opportunity to state the circumstances, 313 accused, he has not stated anything, Lordship. Other persons are stated to be hearsay evidence or come after the incident, Lordship. Moreover, he has come to the place of the occurrence, Lordship, this Shiva Kumar, Lordship, with a scissor in his hand, Lordship. And that too, he has attacked him at the vital part of the body, Lordship, it is neck, Lordship, where Lordship has himself, Lordship seen it has ruptured the force of the impact of the weapon with which he has hit, Lordship. Moreover, Lordship,
But otherwise it is 1 centimeter, 0.5 centimeter. That is why
Lordship,
we are concerned. 1 centimeter is this much
Lordship,
and half centimeter is this much.
this Lordship,
But somehow it had ruptured
upside, Lordship,
the occipital artery
artery, Lordship. Lordship,
because he is not a surgeon
Lordship, Lordship.
that he knows
Where it is,
that by this 0.5 centimeter
Lordship.
wound,
Lordship.
I can pinpoint
And he was dialogue,
that disease was standing.
Lordship. Lordship.
Even a surgeon cannot hit unless he is on the operation table, right? Somehow it appears that he made that, whether he had the intention or the knowledge. That is the core issue.
Lordship.
Does not like that one will proceed to the house of the person, even if he is enemy, that I'll kill him.
No.
Then he will armed with a better thing, knife, big knife, something like that. And instead of a seizure. And that Onita says it is a short one.
But in.
Onita says
Lordship.
short one, PW3, the eyewitness says she discarded the material exhibit 1 and says that it is a short one. So short one with a short knife going to the house with the intention to kill, I think that is too much to be acceptable. He has a grudge, maybe. But then if he had the intention to kill, he will go with an axe, with a dao, with a knife, with a dagger, or a pistol. Pistol is not normally available. So these other things are available. He would not have gone with a seizure. Something developed at the spot.
It is not on record, Lordship.
No, but the arming with a seizure
Lordship.
to go for a killing of a person, I don't think that will be the intention we have to read.
Lordship.
Seizure of 6 inches. And it is very difficult to hold.
Upside down.
You cannot hold this seizure with two finger and put it, because seizure will be like this then. Seizure should be like this also then. 6 inches. The wound size is 1 and 0.5 centimeter. But somehow it created the damage. Might not be the intention, maybe the knowledge. Arming with that is what I am thinking about. Intention and knowledge.
Put one to be.
If he had the intention, he would have gone there armed with a better, sharp, more bigger thing, more weightier. Presence is not there. This PW2, he is a res decia witness. PW3, she is the eyewitness. Even 164 statement is more damaging. Plus PW4, she was there. She was also there as a res decia. Plus Everybody said neck. Corroborated by medical evidence. But still, whether is a case of murder, I think murder নহব। arm যদি intention লৈ পেলাই যদি 6 ইঞ্চি কেঁচিডাল লৈ যায় ন, not repeated blow, only one wound।
Postmortem
এইটো
report,
story থাকিব, এইটো story থাকিব। মই সেইকাৰণে ওলাব দিলো। এইটো
on the right side, Lordship. And even everywhere it is inquest also it is said left side. And in this page 23,
postmortem, where is that?
page 25, Lordship,
25।
5. Page 26, second para, subcontinuous tissue.
Page
left-
26.
Left side. So it may be two, Lordship. Two blows, maybe, Lordship.
Filled with liquid and clotted blood.
But if we look into the inquest report, Lordship, it is on the left side of the neck. Inquest is 60. In page 66.
So what do you want to say? Prosecution case is doubtful.
No, sir, Lordship, two sides maybe on both sides.
Witness says one. Only one blow. What for you are saying now? Maybe left or right, that is the maybe something. But there are no two. Doctor has not said.
Lordship.
Doctor has not said two. Only one. Subcutaneous tissue planes of the whole left side of the neck are filled with liquid and clotted blood. Maybe
Okay,
injury here, clotted blood there, we don't know
okay, Lordship.
what is inside. But where is that? To injury.
No, no.
I have not seen. And he said opinion as a result of the injury,
Injury, not injury.
not injuries.
Not-
Inquest report. Inquest, what is the inquest exhibit?
60,
Hmm?
66,
No, exhibit number.
exhibit number is 2.
Steve. Step. Atak. Doesn't. We'll start at 2. We'll start at 2. Dictation. 2টা বাজে করবো। Yes.
May I read, Lordship? If the act by which the death is caused is done with the intention of causing death, here it may not be. Or if it is done with the intention of causing such bodily injury, Lordship, as the offender knows to be likely to cause the death of the person to whom the harm is caused. So he has caused bodily injury, Lordship, and he has also bring one seizure, Lordship, with him. He may not have the intention of causing death, but he have the intention of causing bodily injury, Lordship.
B will
And
not
he
be
knows.
attracted. B is not attracted.
Lordship.
Suppose B, as has been interpreted in
Lordship.
many decisions, as the offender knows. That means suppose
Lordship.
if Mr. X has heart disease
Lordship.
and he gives the blow at the heart
Lordship.
and knows that that will lead to his death, then
But then that
right.
is the vital part,
That
Lordship.
secondly is clear. Such bodily injury as the offender knows.
No.
Right. Have you heard the Navjot Singh Sidhu story?
Lordship.
Huh? There
Yes,
was some traffic dispute
Lordship.
between him and another person.
Lordship.
Then there was altercation on the road. Then he gave a blow. He being an opener, cricketer, physically fit, gave on the chest. That person had heart disease. Oh, but Sidhu met him on the road only. Right? And he did not know him. And so he did not know that this person has heart problem. He gave a blow. That person dies. So secondly will attract in those situations.
Specific knowledge, Lordship.
Specific knowledge has to be there that this person is suffering from this. If I give a blow,
Previously, Lordship.
yes.
Lordship, thirdly,
Thirdly, yes.
is sufficient in the court, Lordship.
That is intention.
Lordship.
This is
Interpreting 15.
this is also fourthly.
He has Lordship step in the vital part. That is why I'm
Vital part. But we have to see that he has the seizure.
Lordship.
But nobody has said that
But
he
he is
has
not a barber, Lordship. So he should not
not a
have,
barber.
he should not have, Lordship.
He should not have. I know.
Lordship.
But see PW3. Coming here, he directly did not put the step. There was something in between.
But the provocation is not there on record, Lordship.
Still, it is knowledge.
Lordship.
If you come to 299,
Lordship.
see 299, whoever causes death by doing an act with the intention of causing death. Right? This is murder.
Lordship.
Second, with the intention of causing such bodily injury as likely to cause death.
Lordship.
This is also part 1.
One.
Likely to cause death. Third, with the knowledge that he is likely by such act to cause death. This is part 2.
Part 2.
We feel that this is a case of part 2. Hmm? Okay. Conversational last part to that. My case convert person, conversational last part to the I'm not going to answer.
Right. It will most likely continue.
নাই, ওখানেই আছিল। IT আছে না, এটা না। Just explain me. Explain me. Ne explain me.
That's it.
Oh, okay, okay. The present criminal appeal from jail under section 383 Code of Criminal Procedure 1973 within bracket the CRPC or the code for short is directed against a judgment and order dated 18/5/2022 passed by the Court of Learned Sessions Judge Dibrugarh in Sessions case number 72 of 2020. By the judgment and order dated 18/5/2022. Comma. The Learned Court of Sessions. Dibrugarh, huh? Dibrugarh. Has convicted the accused appellant, finding him guilty for committing an offense of murder, comma, defined in section 300, comma, Indian Penal Code. Finding him guilty for the offense of murder, holding that the offense committed by the accused falls within clause thirdly of section 300 Indian Penal Code. And the accused appellant has been sentenced under section 302, IPC to undergo rigorous imprisonment for life and to pay a fine of rupees 3,000, in default of payment of fine, to undergo simple imprisonment for another month. Full stop. The accused appellant has also been found guilty for the offense under section 447, IPC, and for the offense under section 447 IPC, he has been sentenced to undergo rigorous imprisonment for 3 months and rigorous imprisonment for 3 months. Full stop. It has been ordered that both the sentences are to run concurrently. Full stop. The genesis of the trial is traceable to a first information report lodged by one Suraj, Suraj, Suraj Nayak, as the informant. Before the in charge Borbari Police Outpost, Dibrugarh at 12:15 PM on 13/4/2020. Full stop. On receipt of the FIR, the in charge Borbari Police Outpost registered the same as Borbari Outpost General Diary entry number 307 on 13/4/2020. And thereafter, forwarded the FIR to the officer in charge, Dibrugarh Police Station, for registering a case under proper sections of law. Full stop. While forwarding the FIR, the in charge, Borbari Police Outpost, took up the investigation of the case himself as the IO. In charge, Borbari Police Station, Dilip Kumar Kotogi, within bracket PW8. Full stop. On receipt of the FIR, the officer in charge, Dibrugarh Police Station, registered the same as Dibrugarh Police Station case number 629 of 2020. Within bracket, corresponding GR case number, corresponding PSC case number 916 of 2020 and GR case number 1376 of 2020. For the offenses under sections 447/302 IPC. Full stop. Para. In the FIRs, EXT1, the informant dash PW1 had inter alia alleged that at about 5:30 PM on 12/4/2020, the accused, Hibo Kormokar, a resident of Pakka Line, Maidan Tea Estate, killed his father, Bhim Nayak, by stabbing him in the neck with a scissor in the courtyard of the house of the deceased. Full stop. Para. During the course of investigation, the IO PW8 recorded statements of the witnesses under section 161 CRPC, and by visiting the place of occurrence, that is the house of the deceased, a sketch map, he also prepared a sketch map of the PO. EXT6. Full stop. As after the incident, after the incident of stabbing, the family members of the deceased took family member of deceased alive. Bhim Nayak took him to the hospital for medical treatment, but Inquest to put us, inquest. Took him to the Assam Medical College and Hospital at Dibrugarh, AMCH, for medical treatment. Took him to took him to the hospital. Took him to a took him to a health facility for medical treatment, but the doctors there declared him to be declared him to be brought dead. Full stop. As it was informed that post-mortem examination had to be done, 82. Oh, sorry. Prior to the institution of the affair, the family members of Himnayak, in order to provide him medical treatment, took him to a health facility, but the doctors there on examination, declared him to be brought dead. Full stop. As doctors further informed that postmortem examination had to be done. ক'ত নিলে প্ৰথমতে বুজি পোৱা নাই ক'ত নিছে চিয়ৰ নহয় এই আয়ৈ কি কয় বা এইখিনি কাটক অলপ হেৰি আছে এইখিনি পত্ৰ এইখিনি এনেই ব্ৰেকেট থৈ দিয়ক মই কাটি দিম লাগিলে prior to the institution of prior to the lodgement of the affair, it was telephonically informed to the in-charge Borbari outpost by the manager of Maidan Tea Estate on 12/4/2020 that one person had been killed in the Pakka Line area, PUCCA line, LINE area of the tea estate. And on receipt of such information, telephonic information, one general diary entry one entry was made in the general diary of the outpost. Hide. By General Diary entry number 288, dated 12/4 to 2020. Full stop. It was in pursuant to General Diary entry number 288, dated 12/4/2020, comma, the IO within bracket PW8 visited the PO and recorded the statements of the witnesses available at the PO and prepared the sketch map of the PO EXT6. Full stop. As the IO PW8 learned on reaching the PO that Himnayak had already died, he took steps for conducting the inquest on the dead body of the deceased. Full stop. The inquest on the dead body of the deceased was conducted at the AMCH at 10:30 a.m. on 13/4/2020 by an executive magistrate. Full stop. In reference to the General Diary entry number 302, dated 13/4/2020. Full stop. Thereafter, comma, the dead body was forwarded by dead body challan of event date EXT6 for postmortem examination. Full stop. The postmortem examination was performed at the AMCH Dibrugarh at around 1:10 p.m. on 13/4/2020. By Dr. Deborshi Chakraborty within bracket PW7. Who was on duty on that day, that is on 13/4/2010, as a demonstrator, MCH, Department of Forensic Medicine. Full stop. The IO PW8 had, in the meantime, seized one carved steel scissor with a black handle, about 6 inches long, from the house of the accused. At 7:45 p.m. on 12/4/2020, vide a seizure list, MR number 84/2020, within bracket EXT, in presence of witnesses 1, Raju, Roman 1, Raju Kormokar, PW, Raju, ইন্ডেক্সত ভুলকে লিখিছে ৰাজু কৰ্মকাৰ ইন্ডেক্সত কৃষ্ণ লিখি থৈছে PW2 within bracket Roman 2 Onita Nayak PW3 and Roman 3 Jonali Kormokar, within bracket, not a witness. Full stop. The IO PW8 also forwarded Onita Nayak, PW3 bracket, and Sumitra Munda to the court for recording their statements under section 164 CRPC. Full stop. The statements of Onita Nayak PW3 and Sumitra Munda PW4 were recorded under section 164 CRPC on 22/04/2020. Full stop. He to the health facility কৈছিল ন to the health facility নহয় to the casualty department of the AMCH. তাতে আরটা লিখে দেবো। As the disease was brought dead to the casualty department AMCH at around 5:50 p.m. on 12/4/2020, comma, the patients, the particulars of the diseased was forwarded to the officer in charge, Borbari Outpost, Police Outpost, AMCH. And EXC3. And on that basis, comma, General Diary entry number 302 dated 13/4/2020 was registered at 9:30 AM. এইটো মাজত সোমাই দিব তাৰপিছত ফাৰ্ষ্ট ফোন ক'ত আছে 86. After collecting the postmortem examination report, and completing the remaining part of the investigation, Commander IO PW8 laid a charge sheet under section 173 to CRPC. Wide charge sheet number 380/2020 on 22/07/2020, finding a prime facie case against the accused who was named in the FIR, comma, for committing an offense under section 3 for committing offenses under section 447/302 IPC. Full stop. The accused was apprehended immediately after the incident, and after being apprehended, comma, he was produced before the Court of Learned Chief Judicial Magistrate on 13/4/2020. Along with The seizure list, comma, MR number 84/2020. With the seized article. Comma, arrest memo, etc. Full stop. On 13/4/2020. On being so produced, comma, the accused was remanded to judicial custody. Full stop. The court of learned judicial, chief judicial magistrate. After seeing the seizure list as well as the seized articles produced by the IO, comma, returned back the original seizure list and the seized articles to him. Full stop. Since then, comma, the accused is in custody during the course of investigation, comma, inquiry, and the trial. And after the trial, returning with a verdict of guilt, comma, the accused is undergoing his sentence till date. Full stop. একটু এই পার্টটো পিছত ৰাখি থব, এইটো বল্ডত কৰি থওক, পিছলৈ চেভ কৰি দিম। On submission of the search sheet, comma, the Court of Learned Chief Judicial Magistrate secured the appearance of the accused through PC on 22/10/2020. Post of, as the copies were found ready, comma, the same were furnished to the accused in compliance of section 207 CRPC. Full stop. Finding the offense under section, as the offense under section 302 IPC, exclusively triable by the Court of Session, comma, the Court of Learned Chief Judicial Magistrate, by an order of commitment dated 22/10/2020, committed the case records of GR case number 1376/2020 to the Court of Sessions, comma, Dibrugarh, after notifying the learned public prosecutor. Full stop. The jail superintendent was also directed to produce the accused before the Court of Sessions, Dibrugarh, on 5/11/2020. Full stop. Para. On receipt of the case records of GR case number so and so, the Court of Sessions, Dibrugarh, within bracket, the trial court, or short, registered the same as Sessions case number 72 up to 2020. Full stop. On appearance of the accused and after hearing the learned public prosecutor and the learned legal aid counsel for a defense and upon perusal of the materials available in the record, learned trial court, on 4/1/2021 frame the following charges against the accused. Page 6. Page 6. When the charges were read over and explained to the accused, he pleaded not guilty and claimed to be tried. Full stop. During the course of trial, the prosecution examined 8 number of witnesses and exhibited 8 number of documents. Apart from one material exhibit. First, to bring home the charges against the accused. First of the prosecution witnesses টেবুলত আছে টেবুলতে দি দিব পাৰে টেবুল এখন আছে টেবুলতে দি দিব prosecution witnesses examined the documents exhibited documents and the material object exhibited whereas follows বুলি টেবুলখন দি দিব 62 63 পিছত কাটি দিম এই exhibit 81 51 এইবোৰ নালাগে আৰু খালি exhibit after closure of the evidence from the prosecution side, the accused was examined under 313 CRPC for the purpose of providing him opportunity to explain the opportunity to explain for his explanation. So, in order to provide him the opportunity to explain the circumstances appearing against him in the evidence of the prosecution. Full stop. The plea of the accused was denial and according to him, he was falsely implicated. Full stop. After hearing the learned counsel for the parties and upon evaluation of the evidence stock materials on record, the learned trial court proceeded to pass the judgment and order of conviction and sentence, impugned hearing. Full stop. We have heard Mr. A.K. Bhuiya, learned amicus curiae for the accused appellant and Mr. K.K. Das, learned additional public prosecutor for the respondent state. Stop Mr. Bhuya, learned amicus curiae, appearing for the appellant, has submitted that if the testimony of the three witnesses, comma, PW2, PW3, and PW4, comma, projected as vital from the prosecution side, comma, are examined and analyzed together, comma, a number of inconsistencies can be noticed. Full stop. He has further contended that the version given previously by PW3 in her statement recorded under Section 164 CRPC is not consistent with her testimony before the court, given before the court. Comma, thereby, comma, making her a witness which or whose testimony cannot be believed without corroboration from other evidence on material points. Full stop. There are no supporting there is no sufficient, there is insufficient supporting materials, evidence to lending corroboration to the case projected by the prosecution through PW3. Full stop. Neither PW2 nor PW4 deposed or PW4 deposed to the effect that they had witnessed the incident. Full stop. To base, so it is thus not safe to base a conviction on the basis of such discrepant nature of evidence. Full stop. He has further contended that the wound sustained by the deceased cannot be held to be sufficient. And it has not been brought on record by the prosecution that such a wound can be caused by a seizure. Full stop. The seizure, SCISSOR, produced by the prosecution before the eyewitness. PW3 during the trial was found to be one which was not used, and as such, the present one is a case of non-recovery of the weapon of assault. Yes. Full stop. He has alternatively submitted that even even if after appreciation of the evidence, stroke materials on record, a ring of truth, if a ring of truth is noticed, then also the alleged date of the alleged homicidal date of the disease cannot be brought within the scope and ambit of the offense of murder, defined in section 300 IPC. First, para opposing the contentions of the learned amicus curiae, Mr. Das, learned additional public prosecutor, has submitted that the deceased had met his death immediately after the incident, as by the time he was brought to the hospital, AMCH at Dibrugarh, he was already dead. Full stop. The autopsy doctor, from the testimony of the autopsy doctor, PW 7, and the postmortem examination report, EXT 5, it has clearly emerged that the death was a homicidal one. And the death was due to hemorrhagic shock as a result of the injuries sustained over the neck of the deceased. Full stop. As it has also emerged that the injury was caused by a sharp pointed weapon. Ikulu? And a seizure fits the bill fits the description. And the seizure falls in the said category, comma, the learned State Council has contended that no interference is called for. No interference to the judgment and order of the learned trial court is called for. Full stop. That the seizure was used in inflicting the injury has been testified by the sole eyewitness, comma, PW3. Full stop. He has contended that the minor discrepancies, comma, which are not minor discrepancies or inconsistencies, comma, pointed out by the learned amicus curiae, comma, have not created any dent to the core prosecution case. Full stop. He has thus supported the conviction of the accused appellant for the charges framed against him. Full stop. It is his further contention that there was an intention on the part of the accused as he came to the PO with a seizure in his hands. Full stop. Where we have duly considered the submissions of the learned counsel for the parties and have also perused the evidence stroke materials on record, including the testimonies of the prosecution witnesses and the documentary evidence available in the case records of sessions case number so and so in original. Full stop. Para. Out of the prosecution, 7 number of prosecution, 7 or 8 number of prosecution witnesses, comma, the prosecution witnesses PW1, comma, PW3 and PW4 were related to the deceased. Full stop. PW2 is a neighbor of the neighbor to of the neighbor to the house or neighbor of the house to the house. Neighbor to the house of the deceased, comma, where PW1, PW3, comma, PW4 houses go to the houses to that. No, house was the neighbor to the houses. Houses of PW1, PW3, PW4, and the disease. Now where? How to the houses where PW1, PW3, PW4, and the disease used to reside. Full stop. The testimony of PW5, testimony, the evidence given by PW5 is in the nature of hearsay. Hearsay too. Hearsay. And is of no assistance to any of the two sides. Full stop. PW6 comma R. Sharma was serving, comma, on 22/04/2020, comma, as Judicial Magistrate First Class, Dibrugarh. And on that day, comma, PW6 recorded the statements of PW3 and PW4 under section 164 CRPC. Post of PW7 comma, as mentioned above, comma, was on duty on 13/4/2010 in the capacity of demonstrator in the Department of Forensic Science, AMCH Dibrugarh, and on that day, comma, PW7 performed autopsy on the dead body of the deceased. Full stop. PW8 Dilip Kumar Kotoki was the then in charge Borbari police outpost investigated the case as the IO. Full stop. Para. PW3 Anita Nayak is a daughter of the deceased. Full stop. As regards the incident, comma, PW3 testified that on the date of the in the evening hours on the date of the incident, comma, she was in her house and her sister-in-law Sumitra, PW4, was in her house. Full stop. Both their houses were nearby, are nearby to each other with the same courtyard. Full stop. It was at that time, comma, the accused came to her house and asked PW4 to give him a seizure to cut hair. Full stop. But PW4 did not give the seizure, did not give any seizure to the accused. Full stop. It was at that time, comma, the deceased reached his house from work. Full stop. Then the accused asked the disease to give the seizure to cut the hair. চুলি কাটিবলৈ আহিছে, এইটোও নাই। When the diseased did not respond, the accused attacked the diseased on the side of the neck with a seizure. Full stop. PW3 stated that the seizure was brought by the disease from his house. Full stop. As a result of the assault, the disease fell down on the ground. Full stop. Then C had gone out of the house to call her brother, Suraj Nayak, PW1, from the field where he was playing at that time. Full stop. The disease was thereafter taken in a vehicle to the hospital. But the deceased, but her father, that is, the deceased, breathed his last on the way. Full stop. PW3 stated that police personnel came to their house in that night himself and made an inquiry with her. Full stop. The police also seized the seizure from the house of the accused by preparing a seizure list, EXT3, wherein she gave her signature as EXT32. Full stop. When a seizure as MET EXT1 was shown to PW3 stated that the seizure was not one which was seized, and a seized seizure was a small one. Full stop. PW3 also exhibited her statement recorded under section 164 CRPC as EXT4, which are signatures therein as EXT41 and EXT42 respectively. Full stop. During her cross-examination, the defense elicited from PW3 that there was no one at the PO when the incident took place. But Raju Karmakar, PW3 or 2, came to the PO when she shouted. Full stop. A number of suggestions were given to PW3 by the defense, and all those suggestions were categorically denied by PW3. Pusto, does Pusto, para. The fact that police personnel visited the PO, that is, the house of the deceased, on the night of the night when the incident occurred, is also stands corroborated from the testimony of the IOPW 8. Comma, visited the so and so, and also and a seizure was seized from the house of the accused. The facts stand corroborated, stand substantiated from the testimony of the IOPW 8, seizure list MR number 84, 2020, EXT3. Pusto. The fact that dead body of the deceased, sorry, the fact that disease was forwarded and the death of the deceased had occurred prior to (5:50 p.m. on 12/4/2020) is evident from the intimation letter of the doctors of letter EXC7. তারপর মাউলি বেঁচে তো আমি ইঞ্জিনিয়ার করেছি 5:30 লেট শর্ট করবো কারণে from the doctor's order and progress note AMCH Dibrugarh EXT7 issued on 12/4/2020 to the officer in charge, to the in charge Borbari outpost, police outpost, comma MCH. Posting. এইখিনি corroborate কৰিলে। In her testimony, comma PW 4. Stated that the incident had occurred in the evening hours post of at the time of the incident, comma, she was standing in the courtyard. Post of the accused came to their house first, and thereafter the deceased reached his house. Full stop. At the time, comma, she went inside the house, but she had to rush out of the house, hearing screamings of the daughter of the deceased, comma, Onita. Nayak, PW3. Post up. She saw that the disease was lying on the ground with blood oozing out from the side of his neck. Post up. Sunita then went out to call her brother. Full stop. তার আগত লিখব এইটোৰ আগত from the side of the neck. The accused was found standing there at that time. Full stop. Sunita PW3 will color. Then went out of her house to call her brother. Full stop. The accused thereafter left for his house. Full stop. The accused thereafter was taken to hospital Full stop. Police personnel visited the PO in night. Full stop. PW4 stated that Onita Nayak, PW3, was present near her father, comma, that is the deceased when the incident took place. Full stop. একটু আগত পিছত কৰিব লাগিব উল্টা উল্টাকে কৰিছে The police also inquired about the incident from her and Post of PW4 further stated that her statement, her statement was recorded. No, sorry. She was brought to the court to record her statement, wherein she put her thumb impression, full stop. During cross-examination, hey, a number of suggestions লিখি দিব আগৰ ৰিপিট কৰি দিওঁ হা categorically denied এই ইয়াৰ জাষ্ট আগৰ পৰাটো ইয়াত এতিয়া লৈ আহিব হা the fact that the daughter of the deceased, Anita Nayak, PW3, was present at the time of the incident, as the PO received corroboration from the testimony of PW4. Full stop. The testimony of PW3 that the accused came to the courtyard of the house of the deceased is also corroborated by PW4. Full stop. The testimony of নাই এইটো ঘূৰি যোৱাটো কোৱা নাই নহয় জানো ঘূৰি যোৱাটো কথা একিউজ ঘূৰি যোৱা কথাটো সি দেখা নাই এই কোৱা নাই PW3 নকলে কৈছে দেখা নাই কৈছে জানো ক'ত কলে ওৰে কৈছে নাই কোৱা 164 কৈছে ইয়াতে কোৱা নাই PW2 Raju Karmakar is a neighbor to the house of the deceased. And to the houses of the deceased and the accused. Full stop. PW, in his evidence in chief, PW2 stated that the occurrence on the date of the incident in April 2020, he was having lunch in his house at around 3/3:30 p.m. Post op. At that time, he heard screamings of Anita Nayak, that is PW3, that is the daughter of the deceased, that her father, Bhim Nayak had been killed. Pusto. PWC then immediately rushed out of his house to reach the PO, to reach the house of the deceased. And then he saw the accused coming out from the courtyard of the house of the deceased, uttering that, page 20 আছে, quote unquote কৰা আছে, মই কৈছিলো নহয় মোৰ লগত নেলাগিবি, কমা, যি হল এতিয়া তহঁতে বুজিবি, unquote. Bracketer ভিতৰত, I told you not to confront with me, comma, now you would understand, you would understand what had happened, what has happened, and bracket close, full stop. PW2 stated that the accused crossed him while going out. Full stop. At the courtyard of the deceased, comma, PW saw the deceased lying on the ground with blood coming out from a cut injury on his neck. And the deceased was making some hissing sound from his mouth. Full stop. PW2 then came out and called a cousin of the deceased named Rajesh. Full stop. But though Rajesh is not a witness, did not come to the PO, one Bholu Nayak, who was an uncle of the deceased, came to the PO and called an ambulance to take the deceased to a hospital. Full stop. It was on that night itself, police personnel came searching for the accused. And at that time, PW2 narrated the incident to the police. Full stop. PW2 stated to have heard that the disease was referred to the AMCH from the Garden Hospital, and on the way, he expired. Full stop. When police personnel came to the PO, he, PW2, along with the police personnel, entered into the house of the accused. And there, the daughter of the accused showed a blood-stained seizure kept on the table. Full stop. The said seizure was seized by the police, by a seizure list, EXT3, wherein he gave his signature as EXT31. Full stop. When a seizure was shown to PW2 as MET EXT1, he identified the seizure to be the one which was seized in his presence from the house of the accused. And at the time of the seizure, the accused was not present in his house. Full stop. In cross-examination, comma, PW2 denied that no, PW2 stated that he had a grocery shop adjacent to his house. And when he came for lunch, the shop was kept open. Full stop. It was elicited by the defense from PW2 that Anita Nayak, the daughter of the deceased, comma, Anita Nayak, PW3, and Sumitra, PW4, were near the deceased at the time of the incident. Full stop. PW2 denied the suggestion that he had deposed falsely due to old grudge against the accused. Full stop. Para. From the testimony, in his testimony, PW2 had supported the from the testimony of PW2, corroboration is found on the point that at the time of the incident, comma, the two prosecution witnesses, comma, PW3 and PW4 were present near the deceased. Full stop. From the sketchment of the PO, comma, EXC3, it is evident that two houses were nearby. With the same courtyard as testified by PW3 and PW2, PW3 and PW4. Full stop. The fact that the house of PW2 is near to the house of the deceased and the accused has not been disputed by the defense in any manner whatsoever. Full stop. If an incident like stabbing on a father occurs, it is natural for a daughter to react by screaming. Full stop. And it is also nature for a neighbor like PW2 to hear such screaming and after hearing screaming, comma, to proceed for a PO. Comma, at least out of curiosity. Full stop. Though it has emerged that PW 2 and PW 4 did not witness the incident at that point of assault on the point of assault on the neck of the deceased by the accused, but these two witnesses had but PW 4 had witnessed the events followed after the assault. Full stop. Similarly, PW 2 witness the events which occurred after the assault. Full stop. On a combined reading of the testimonies of PW 2, PW 3, and PW 4, it is found to be established that at the time of the incident, the deceased and the accused were present in the courtyard of the house of the deceased. And the deceased sustained the injury on her neck full stop. All the prosecution witnesses, all these three prosecution witnesses, PW 2, PW 3, and PW 4 had categorically testified that the disease, after sustaining an injury, the disease sustained an injury on his neck, and from the injury, blood was oozing out. Full stop. We now turn to the medical evidence led by the prosecution in the case. So the medical evidences are present in the forms of the testimony of the autopsy doctor, Dr. Deborsi Chakraborty, who testified as PW 7, and the postmortem examination report, which was exhibited as EXT EXT ফাইল EXT কিমান আছে 5. Post. PW7 stated that the postmortem examination on the dead body of the deceased was performed on police requisition on 13/4/2020. Post of the dead body was brought and identified by EBC, Simanto Kaur. Post of. After performing the postmortem examination, PW7 recorded the findings in the postmortem examination report PW5 in the following manner. Page 75 or page 75. Page 75 or pencil or পেন্সিল বাকি না লাগে আর ইঞ্জুরিটো লিখিলে হৈ যাব চাগে ইঞ্জুরিটো লিখিলে হৈ যাব এইটো পেজ 75 পেন্সিল টু পেন্সিল in PW7 further testified that after recording the findings, he reached the opinion that the death was due to hemorrhagic shock as a result of as a result of the injuries sustained over neck. He gave his opinion as under a page 79 of pencil to pencil. Type করে ভুল করেছে বাদ দিয়ে করা ইউর সিন সি ধরিব পৰা নাই ধৰিব পৰা নাই কাৰণে মই লিখা নাই চালো মই হাজবেণ্ড বা ৱাইফ একো লিখা নাই দুইটা নামটো মেলৰো হয় ফিমেলৰো হয় সেইকাৰণে মই লিখা নাই like in the postmortem examination report EXC3 when the executive magistrate conducted the inquest proceeding like so and so, the executive officer, after conducting inquest proceeding, reported in the inquest report EXT two. At the time of recording his findings, that there was an injury mark on the neck of the deceased. And he further recorded that from the appearance, the cause of death might be due to stab injury with sharp weapon. On a comparative, on a combined, from a combined reading of the testimonies of the aforementioned prosecution witnesses and medical evidence, it is established that a disease sustained an injury on his neck, and the said injury was the cause of his death. Full stop. The injury was that death was due to hemorrhagic shock as a result of the injury sustained. And the injury was antemortem in nature. Full stop. The injury was caused by a sharp-pointed weapon and was homicidal in nature. Full stop. The autopsy doctor PW7, neither the autopsy doctor PW7 was not confronted by the defense in any manner whatsoever with regard to the opinion rendered by him. Also, the defense did not also lay any challenge to the findings recorded in the postmortem examination report EXT5. Full stop. The testimony of the informant, from the testimony of the informant SPW1, it is found that at the time of the incident, he was not at the place of occurrence. So according to him, at the time of the incident, he was playing at a place in his village, and it was PW3 who came there to inform that their father had been killed by the accused. Full stop. On being so informed, by the accused by attacking him with a seizure. Full stop. On hearing the news, he came to the to his house and finding his father injured, took him for medical treatment. Full stop. PW1 stated that after postmortem examination, the dead body of the deceased was taken to their house to do the rituals. Full stop. Thereafter, the FIR EXT1 was lodged. EXT2 কি বস্তু? Yeah, full stop. PW1 further stated that in the inquest report, he also gave his signature. Full stop. Para. The defense has raised a point that by the seizure list MR number 84, 2020, one carved steel seizure with black handle, about 6 inches long, was seized from the house of the accused. Full stop. In presence of a number of witnesses, in presence of 3 witnesses, mentioned above. Full stop. One of those 3 witnesses, PIJ, Anita Nayak, PW3, the daughter of the deceased, was the one who claimed to have witnessed the incident of assault on her father by the deceased with a seizure. Full stop. According to the defense, when a seizure was, as MAT EXT1 was shown to PW3 before the court, PW3 stated that MAT EXT1 was not the seizure which was used in the assault. Full stop. On the other hand, PW2, who was also a witness to the seizure list EXT3, testified when MAT EXT1 seizure was shown to him in the court, that it was the one which was seized by police on 12/4/2020 by the seizure list MR number so and so EXT3. Full stop. As the evidence of PW2 and PW3 as regards the seizure, MAT EXT1 are at variance with one another, the factum of recovery of the weapon of assault has come under a cloud and in turn, comma, the entire prosecution case has become doubtful. Full stop. The ground raised by the defense as regards the weapon of assault after consideration, comma, is found to have not created a serious dent to the core of the prosecution case. Full stop. The identification of the seizure in a different manner, in different manner by the two seizure witnesses, PW3, 2 and PW3. Is suggestive of no, goes to indicate that either the actual, either the seizure মানে SCISSOR, huh? কেচি বুলি কৈ দিম, seizure বুলি ধৰিব। Either the কেচি seized on, নহলে seizure কৈ আছো ন, দুটা seizure হৈ আছে না। Either the কেচি seized on 12/4/2020 was not presented before the court or different seizures were presented before the court on different dates. Full stop. The same might be a defect on the part of the investigating authority or on the part of the prosecution. Full stop. The same, we are of the considered view, the same would not inure. Such defect would not result in any benefit to the accused for the fact that the ocular evidence of the prosecution witnesses, PW2, PW3, and PW4 are found to be consistent and reliable all throughout. Full stop. It is true that the prosecution witnesses, PW3 and PW4, are closely related to the deceased. Full stop. But for the said fact, their evidence cannot at all be thrown out. Full stop. If their evidence is found to be consistent and true, the fact of being a relative cannot by itself discredit their evidence. Full stop. As interested on the ground, on the allegation that they were interested witnesses. Full stop. A witness may be called interested only when he or she derives some benefit from the result interest and witness, a related witness. No, uh, mm, um, there can be two categories, firstly, a related, and therefore an interested witness having an interest in seeing the accused punished. The real accused punished, real accused punished. And secondly, a related, and therefore an interested witness having an interest in seeing the accused punished and also having some enmity with the accused. In respect of the second category of the related and of the related and interested witnesses, a more a stricter scrutiny is required than while appreciating their evidence. Full stop. Even on the strict scrutiny test, we find the evidence of the PW2 and PW3 and PW4 as consistent and reliable and trustworthy to inspire the confidence of the court. Full stop. PW2 though For the purpose of appreciation of the evidence of PW two, comma, a reference to the rule of evidence embodied in Rule 6 of the Evidence Act appears necessary, full stop. PW 6 of the Evidence Act is an exception to the general rule wherein the hearsay evidence becomes admissible. Full stop. But for bringing such hearsay evidence, we need the provisions of Section 6, comma, what is required to be established is that it must be almost contemporaneous with the acts, and there should not be an interval to allow the mind to make any improvement or embellishments. Post of the statement sought to be admitted, therefore, as forming part of Rule Asia, must have been made contemporaneously with the acts or immediately thereafter. Evidence evidence as per Section 6 of the Evidence Act, bracket relevancy of facts forming part of same transaction, bracket close, comma, facts which main provision to লিখে দিব। Illustration within bracket A, which are quoted hereunder, comma, has aptly demonstrated the said rule. A to লিখে দিব। A is accused of the murder of B by beating him. Whatever was said or done by A or B means A, ইয়াতে মানে আমার B accused, A or B আমরা A হবো, or the bystanders at the beating or so shortly before or after it as to form part of the transaction is a relevant fact. লিখে দিব। In the Honorable Supreme Court, in Zantella Vijaya Vardhan Rao versus State of UP, 1996, 1996. এই Zantella লিখে বসুন, Zantella, Zentela. Considering Zantella লিখে রাখো, Zentela, 1996. Considering the law, rule of evidence embodied in Section 6 of the Evidence Act has held as under. The utterances made by the accused while leaving the place of occurrence, whose part and who I am made by and heard by PW2 while entering the house of the deceased is admissible in evidence by the rule of evidence embodied in Rule 6. Embodied in evidence by the rule of res judicia under Section 6 of the Evidence Act. Full stop. From the utterances made by the accused is suggestive of an act of assault by him, lending corroboration to the case of the prosecution. Full stop. Para. So, no? The issue which now confronts this court is whether the offense falls in the category of culpable homicide amounting to murder or not amounting, or culpable homicide not amounting to murder. Full stop. The offense of culpable homicide is defined in Section 299 of the Indian Penal Code, whereas the offense of murder is defined in Section 300 IPC. Full stop. As per Section 299, IPC, whoever, লিখি দিব। Full stop. লিখি দিব গোটেইখিনি কন্টেন্টটো। Culpable homicide is the genus and the offense of murder is species, meaning thereby, all murders are culpable homicides, but all culpable homicides are not murders. To bring in a case of culpable homicide within the scope and ambit of murder, the clauses prescribed in Section 300, any of the clauses, that is, firstly, secondly, or thirdly, or fourthly. The clauses, no, the conditions mentioned in any of the clauses, that is, firstly, secondly, any of the clauses, conditions required in any of the clauses mentioned therein has to be present, has to be satisfied. Full stop. Section 300 IPC reaches under kuri murder opra okol fourthly loi dibole hobo, murder opra okol fourthly loi dile hobo. There are 4 exceptions and there are 4 exceptions provided therein. Provided there are also 4 exceptions provided in Section 300 IPC. Full stop. if an offense, despite fulfilling all the conditions of any of the clauses stated therein, comma, comes within any of the exceptions, then the accused is punished when the accused, then it is to be held এই লাইনটো থৈ দিয়ক, এই লাইনটো থৈ দিয়ক for the time being. Then লিখক. Then the offense would be punishable, would be culpable homicide not amounting to murder, punishable under the first part of section 304 IPC. Full stop. In Pangaya versus State of Tamil Nadu, reported in 2005, 9 SSC 650, comma, it has been explained that for the purpose of fixing punishment, comma, proportionate to the gravity of the generic offense, comma, the penal code practically recognizes 3 degrees of culpable homicides. Full stop. The first is, comma, what may be called, comma, culpable homicide of the first degree. এই para 27 আছে মাৰি দিছো হা So this is the greatest form of culpable homicide, comma, which is defined in section 300 as murder. The second may be termed as culpable homicide of the second degree. So this is punishable under the first part of section 304 IPC. Full stop. Then there is culpable homicide of the second degree. No, third degree. Full stop. This is the lowest type of culpable homicide, and the punishment provided for it, comma, is also the lowest amongst the punishments provided for the 3 grades. Full stop. Culpable homicide of this degree is punishable under the second part of section 304, comma, IPC. Full stop. Centella to money. এই আনহাজ বাহিনীর উপর ইয়াৰ পৰা কৈ দিওঁ আৰু লিখিব নেক্সট পেৰা তাৰে সেকেন্ড পাৰ্টটো লিখিব It has been explained in State of Andhra Pradesh versus Raya Bharapu Punaya. Second পার্টটো লিখি দিব where it has been held. It has been observed in এটা কি আছিল না Anbaz Haga versus state so and so reported in 2023 10 SCR 1091, comma, the difference between the two parts of section 304, comma, IPC is that under the first part, comma, the crime of murder is first established and the accused is then given the benefit of one of the exceptions to section 300 IPC. While under the second part, comma, the crime of murder is never established at all. Full stop. For the purpose of, it has been held that for the purpose of holding an accused guilty of the offense, punishable under the second part of section 304 IPC, the accused need not bring his case within one of the exceptions to section 300, comma, IPC. Full stop. একটু কোটা সেবা knowledge or intention. মোটু দেখেন এই মোটু কোটা সেবা ইয়াতে আছে এইটো নাই মোটু একেবাৰে মাৰ্ক কৰিছে ওলাব হুম 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 in determining একটা professor এইটাতে আগতে মিস কৰিছো law is settle that if there is a direct evidence in the form of eyewitness, even in the absence of recovery of the weapon, actual weapon of assault, the accused can be convicted. Full stop. It is also settled that recovery of the weapon used in the commission of the offense is not sine qua non to convict the accused. Full stop. A reference to the decision in state through the Inspector of Police versus Lali, alias Monikandon, 2022-15 SCR 613 can be referred to. Full stop. এইটো মাজত হবে আগত অলপ আগত লিখি থৈ দিয়ক ফিট কৰি দিম the intention to cause ইয়াৰে পেৰা 34 টো দি দিব ইয়াতে হেৰিত আছে intention to cause পেৰা 34 টো death can be gathered generally from a combination of a few or several of the following among other circumstances. Nature of weapon use এনেকে বহুত কেইটা আছে reverting back to the facts of the case in hand, we find that nothing has been brought on record by the prosecution that there was any kind of previous enmity between the accused and the deceased. Full stop. None of the vital prosecution witnesses, PW2, PW3, and PW4 had deposed that the deceased had any or disease, either the deceased or the accused was, or any of them was adversely disposed against one another. Full stop. From the evidence of PW3, it has not emerged that the initial period during his presence, the deceased had shown any kind of aggressiveness. Full stop. Even, full stop. It is true that it has emerged from the evidence on record, when, sorry, deceased, no, accused, good question again. Accused has shown any act of aggressiveness. Disease no. It is true that when the accused came to the place of occurrence, it is true that from the evidence on record, it has emerged that the accused, when he came to the courtyard of the house of the deceased, he had a seizure in his hands, which he had brought with him. Full stop. From the seizure list, EXT2, MR number so and so EXT2. one carved steel scissor with a black handle, comma, about 6 inches long, comma, was shown to be seized in presence of PW3, comma, the sole eyewitness. Full stop. When a seizure as met ext 2 was shown to PW3 in the court, comma, PW3, the sole eyewitness, stated that the seizure met ext 2 was not the one which was used by the accused in assaulting the deceased. And PW3 proceeded to state the seizure which was used in the offense was a smaller one. Who's the meaning thereby, comma, according to the sole eyewitness, comma, the seizure used in the offense was smaller than 6 inches. Full stop. The wound comma described in the PME report EXT5 was a stab injury of size 1 cm x 0.5 cm x muscle dip. Full stop. Despite other than causing damages in various manners, comma, the injury had caused damage to the occipital artery, and the artery was found to be completely ruptured. Full stop. It cannot be denied. It cannot be denied. No, but the autopsy doctor has opined that the injury was antemortem in nature and was caused by a sharp-pointed weapon, and also was homicidal in nature. Also, it cannot be denied, comma, in view of absence of any kind of challenge by the defense, comma, the death was a homicidal one. Full stop. The question is whether the crucial point is whether the accused had the intention to cause death, to bring the homicidal death to fall either in the category of homicidal, culpable homicide of the first degree, or in the category of homicide, culpable homicide of the second degree, or had the knowledge, or or the act would fall outside of these two categories. Full stop. The event of entry of the accused was not preceded by any kind of incident to prevent him to enter into the house or stroke courtyard of the accused without any preparation. Full stop. In other words, comma, the accused had all the time to prepare himself with a weapon of assault of his from the choices available to him before entering the courtyard stroke house of the accused. Available to him like an axe, a sword, a dao, a knife, or a dagger, etc. Huh? Before so entering the house. But it was only a seizure, that too, lesser than 6 inches, 6 centimeters. Huh? Oh, 6 inches. অকমান ডাঙৰ, ইমান মান। Lesser than 6 inches. Full stop. The assault was made when both the accused and the deceased were in standing positions. Full stop. It is though the assault, it is not, it is difficult to comprehend that the accused standing in such position by causing an injury of the size mentioned above and having an intention to cause rupture to to cause damages of the cause damages recorded by the autopsy doctor. Possible question, it is difficult to comprehend, no? By so causing of the size of so and so, no? To cause damages. Full stop. The having considered all the surrounding circumstances, having considered the circumstances preceding, attending, and succeeding the incident of assault, we are of the considered view that the assault was made without the requisite intention to cause an act on the part of the disease to bring the act within the scope and ambit of either of the offenses, culpable homicide of the first degree or culpable homicide of the second degree. Full stop. The act is, however, due to the injury resulted on the deceased, led to an almost instantaneous death of the deceased. Full stop. Therefore, it cannot be denied that the offense committed by the accused is culpable homicide, but it is culpable homicide of the third degree. Full stop. Therefore, from the facts and circumstances of obtaining the case, we are of the considered view that the act of the accused would bring the offense which is punishable under Part 2 of Section 304 of the Penal Code. As the accused had caused one bodily injury on the person or deceased, which was likely to cause the death of the person. Full stop. In such backdrop, full stop, the accused had no what is it? What is that? Point of sentence for questioning. Point of sentence. Point. Four 47 আহিব জানো?
Yeah, no option. But when bad night we enter on the computer because
না, সেইটোৱে।
you
সোমাই আহিছে কিন্তু এইটো প্ৰথম ইণ্টেনশ্যনটো নাছিল। সেইটো আহিলেতো সোমাই আহিলেতো মানে সি পথাৰ লৈ আহিলে বুলি কৈছো ন, লৈ আহিলে। এইটো যদি নাই 447 কথাটো ক'ব লাগিল কিবা 447 ক্ৰিমিনেল ডেফিনিশ্যনটো ক'ত? এইটো as from the circumstances, this preceding, attending, and succeeding. Dash. As from the preceding, attending, and succeeding circumstances. Hmm. To the incident. We no intent. No, as from the preceding and attending circumstances, comma, no intent to commit an offense at the time of entering, at the time of going to the, at the time of his entry to the courtyard of the house of the accused who deceased was found, comma, the conviction and sentence for the offense under section 447 IPC is found unsustainable in law. তাৰপিছত লিখিব the accused, and there is there is nothing on record to suggest that the accused had been convicted earlier for an offense prior to his conviction and sentence in the case in hand. Full stop. The accused is a কি করে come is a we are not discussing 313 is a worker, was a worker in tea garden and has a family consisting of his wife and a daughter. Full stop. At the time of his conviction, comma, the accused was aged 31 years. Full stop. Having regard to all full stop para. Accordingly, this criminal appeal is partly allowed by converting the conviction of the accused appellant from under section 302, IPC to section 304, part 2 IPC. And the sentence is altered from rigorous imprisonment to life, for life, to rigorous imprisonment for 8 years by maintaining the fine imposed upon the accused appellant with the same default stipulation. কি মান আছিল default stipulation? No, with the same default stipulation. As passed by the learned trial court, comma, for the offense, as same default stipulation. Full stop. It is observed that the period of detention already undergone by the accused during the course of investigation, inquiry or trial shall be set off in terms of section 428 CRPC. Full stop. Any compensation? We also reiterate the direction given by the Land Trial Court as regards award of adequate compensation to the family of the victim in terms of the provisions contained in section 357A CRPC of the code and the extant victim compensation scheme framed thereunder. Full stop. Before parting with the records appreciation A.K. Bhuiyan records sent back 8 years. He's already 5 years, 1.5 year. He will